I will.
May I be permitted to mention item number 94, adjournment. So Lordship had already heard the matter on last Monday, recorded my submission, and fixed the matter today on the prayer of the learned advocate for the Union of India. But your Lordship, the matter is very. You know the list. Lordship, kindly see
The
that-
other matters have also been fixed as per the court's direction, right? So please wait for your turn. Yes.
94, item number.
Please wait for your turn. Yes.
May I will also kindly to mention upon notice one new motion of the year 2026. It was released by Justice Mitro for lack of determination. It's a Group 6 matter. The urgency is that we are contractual employees of West Bengal Higher Secondary Education. Our services were terminated, saying that
West Bengal Higher Secondary
education ka.
Education?
West Bengal Higher Secondary Education.
What does West Bengal Higher Secondary Education mean? Is it the board?
Yes, Higher Secondary Education Board. Yes.
So
So-
till you mention the whole thing,
Yes, West
it
Bengal Higher
is
Secondary
difficult.
Education Board. Now, we were contractual employees. Our services were terminated, saying we do not require your services now. Immediately after our services were terminated, they started engaging new contractual employees without issuing any advertisement, without any recruitment process. The entire process is not fair. It's not transparent. So let's kindly.
Give.
Madam, may I permit-
But next, it will appear next Monday. We hardly have time this week.
Next one.
May your Lordship kindly.
No, there are many ready for hearing matters. Please do not mention. No question of monthly list. Every day, the daily list is being published. Yes.
Tribunal matter, Lordship. It was filed on Friday on 24th, Lordship. What happened? The part-time workers, they are deprived of their monthly remuneration. For
But then today is not the day for mentioning. Why are you mentioning today?
No,
Please do not mention. No, sorry.
not
Yes.
not yet appeared
No,
in the
nothing.
list, Lordship. I will serve the notice.
Sorry. Yes, sir.
Please do-
Because I am
please date,
mentioning this
Lordship.
matter. This is not in your lordship's list.
Yes.
I mean, this is a 2024 motion. It was once taken and was fixed in
Who
January.
is your junior? Where is the advocate on record?
This year, yeah?
Yes. Why are you mentioning? Mentioning usually done by the junior members. Seniors, please leave this place for the juniors, at least for mentioning. Right. And today is not the day. I am not taking up any matters for inclusion and upgradation. So, not today. Yes. Nothing.
I have a different matter.
Yes, please.
There was this petition which was disposed of 16653 on 24th of March 2026 with a direction to the 27th Battalion of the BSF to consider the representation of the petitioner and dispose it off. Now the problem is the petitioner had wrongly represented to the court that it is 27 Battalion. It is actually the headquarters of the BSF who can dispose of this representation. So, Your Lordship, the correction to that extent,
You are for the authorities?
I am for the authority, for the
Who is
BSF.
the petitioner?
Your Lordship, I have given him a mentioning notice, Mr. Chirantan Sarkar. I'm mentioning upon notice.
Yes.
So, Your Lordship, if
You give, it will
the
appear under the heading to be mentioned and let the file be
I'm so
brought.
grateful. I'm so grateful.
Madam, may I permit to mention for contempt application? Sir, matter-
Call the list, please.
Your Lordship, may I be permitted to mention a matter, Your Lordship? On the other occasion, Your Lordship, the advocate on record has mentioned the matter, Your Lordship, and Your Lordship, Your Lordship has directed us to come today for the same mention. Your Lordship, the petitioner is a deceased person, Your Lordship, and we have.
Petitioner is a deceased person.
Yes,
He
Your Lordship.
is not here. Petitioner has
Your Lordship,
died. Let him die.
The last
Nothing.
order it was directed.
Item 1. Vertical side, item 1. Please come. Yes.
Time to file a. Yes, I have served upon.
Item 1.
Item number 1.
No.
Yes.
He's praying for extension.
Enough time to file the opposition.
By mistake, he has said extension of interim order. No.
Man, kindly extend for a 2 inch. Old records.
To which, my lord, I am
Opposing.
Yes.
Yes.
Because, my lord, kindly see para 10 of your lordship's order, my lord.
Recruitment process long back. Appointments have been
Yes.
given. Department does not have in the records.
Yes.
Yes.
So, my lord, this is completely wastage of time. 6 weeks time, lordship was pleased to grant. Another 2 weeks time, my lord, is there, my lord, for me. That can also be taken up by him.
No.
But
But because of the old record, but now the commissioner of police has been transferred. You and the
Taking, my lord.
All right. No, one chance. Let me give. Then please come. The matter has appeared in the list under the heading to be mentioned at the instance of the learned senior counsel representing the state respondents. Stop. Prayer has been made for extension of time for filing the affidavit in opposition. Stop. Learned advocate representing the petitioner opposes the prayer. Stop. It appears that paragraph. Video order dated 18th March 2026, comma, not video, in the order dated. The court recorded that the recruitment process is long over and appointments have been given long back. Stop paragraph. To give one more chance to the respondents to file their, to disclose their stand by way of filing the affidavit, comma, time to file the affidavit in opposition stands extended for how many days?
2 weeks.
Today is 27th of April. 2 weeks comes to 8th of May. I will give you more time. Till 20th of May, 20. Today is 27th of April. A reply, if any, may be prepared and circulated by 10th June 2026. Stop. It is made clear that no further extension of time will be granted to the respondents to file their affidavit. Stop. If the affidavit is not prepared and circulated within the time limit as stipulated herein above, the matter will be decided on the basis of the documents already on record.
I'm grateful.
Name turning. Mr. Bhattacharya is appearing on behalf of the petitioner. He is engaged in court room number 1. Your lordship, I bring for short purpose.
Original side matters passover cannot be granted.
But kindly keep it, but after 2 weeks, my juniors have all gone for.
Elections.
Yes.
Accommodation has been sought for on behalf of the learned senior counsel representing the petitioners. Accommodation has been sought for on behalf of the learned senior counsel representing the petitioners. Stop. On such prayer, hearing of the matter stands adjourned. Stop. Released on 15th June.
I'm grateful.
I appear for the petitioner.
I appear for the response.
I'm supposed to, I'm an employee of ACCL, Southeastern Coalfields Limited. I'm supposed to retire in 2 days, on 30th April. I have appeared in an examination for seniority. I was successful and my name has been published in the seniority list. It is, I am in serial number, in the list I am serial number 60, but if in ACCL.
Is 5, 6 and 7 appearing? The matter
I
stood
have the
adjourned.
instructions.
Lordship, as per Lordship, last direction.
It's all right, because last occasion
Yes,
it
yes,
was
that
there
was
and
pointed out.
pointed out to the court. All right. Yes.
Oh,
Then it is all right.
7th, I am sure. 7 Election Commission.
Oh, no. Sorry.
Lordship, thereafter, Lordship, in the list I am there. In 30th April, Lordship, I request them that there are two criteria. One is I am supposed to be given the seniority posting in the same organization, because there is a rule that if I am going to retire in next 2 years, then I am supposed to be absorbed, given the seniority post in the same organization. So there is no question of transfer. So they said that I cannot transfer because of the model code of conduct, Lordship. That's no more there. Lordship, perhaps my learned friend did not say, Lordship, this was what I've transpired from the authorities, because that's why I pleaded Election Commission has been made a party. The second issue was that I cannot jump the seniority because the seniority list, because I am serial number 4 and there are others who are required to be posted. Lordship, this is only, my lord, in 3 days, there is no effect in my salary, because for 3 days, the only thing that I'm going to get is the post-retirement, the benefits that will be better if the seniority is affected. For that reason, I have approached your lordships. Because, lordship, if I am not, the seniority list is not going to be implemented, and in next 3 days I am going to retire. Lordship, I am going to miss an opportunity, my lord.
All right. Yes.
So, my lord, that is why, my lord, it was my humble request to them that at
To
least
give effect to the seniority list.
give an effect, and
Very well, I got it. Yes.
even notionally also, if they can accommodate.
Right
me.
now, no question of notional,
No, I
because
think
you are still in
my lord,
service.
Yes, I am in service.
the petitioner, as my learned friend told you, Lord, my lord, the petitioner due to retire on 30th April 2026. My lord, pre-retirement notice was given to him on 17th April 2025. Now, my lord, DPC sat for consideration of the 8 subsidiaries of the Coal India Limited on 15th March 2026. This is, my lord, promotion for consideration from non-executive cadre to executive cadre E2 level. Now, my lord, your losses will find at the promotion list at page 19. This was DPC issued. At the bottom, your losses will find at page 24. Promotion order will be issued subject to eligibility and up-to-date clearances along with place of posting. Now, my lord, we have now received all the up-to-date clearance, all that. We have to check it up. Now, in the particular subsidiary, my lord, there are 5 other persons also. So I have to give effect them first. Now, these are being considered. None of them have been promoted. Their losses 122, none of them. So this is still under consideration. It is not possible to give the benefit. It's not a matter of right, my lord, what my learned friend is asking for. This is one thing. And the other thing, if your losses kindly consider this, we have, my lord, this is being delayed. This my lord, I just put a tick mark because
What is it? Read out.
my lord, this is manual of the Election Commissioners. No appointments or promotions in government or public undertaking shall be made during this period without prior clearance of the commission. This is not a question of transfer, all that. It's a promotion. This is another factor they are considering. So apart from these, my lord, these 8 subsidiaries, all the papers has to be considered one by after other. And then your losses. My lord, fortunately or unfortunately, he is going to retire 2 days. So it cannot be given.
Please come.
It's not a matter
Lordship,
of
2 things. Lordship, the promotion, lordship, the list has been published on 15th March 2026. That is, lordship, page 19. Lordship, so, my lord, at that point of time, there was no this model code.
Do you think it's automatic? The moment it is published, everybody gets promoted. It is not.
It is not automatic,
Then?
but I am eligible in
Please
view
come,
of the
please
fact
come.
that I am bound to be
The
promoted
petitioner-
because of the vacancy. Because the
The
vacancies are much
petitioner
more, 265.
Is
So,
serving
serial 4.
in the Southeastern Coalfields Limited?
Exactly.
All right. Stop. He was recommended provisionally for promotion to the post of senior officer within bracket excavation in E2 grade based on DPC held on 13th March 2026. Stop. The list of eligible candidates recommended for promotion was published on 15th March 2026. Stop. The promotion order was to be issued subject to eligibility and up-to-date clearances
Yes.
along with the place of posting.
They say that is done.
Stop. The subject to eligibility and up-to-date clearances along with the place of posting. So, paragraph, the petitioner is due to retire from service on superannuation on 30th April 2026. Stop. It has been submitted that if the order of promotion is not made effective prior to his superannuation, he will lose financially. Stop. Prayer has been made to direct the authority to give effect to the promotion list without any further delay, and more particularly prior to the retirement of the petitioner. Paragraph. Then a senior counsel representing the respondents 1 to 6. Submits upon instruction that admittedly, the petitioner's name appears in the list of recommended candidates for promotion.
Against serial number 60.
Against serial number 60.
60.
60 in the entirety. In ACCL, I'm serial number 4.
Stop.
That was my submission of my learned friend on the last occasion.
The
Today also here.
seniority list was prepared in respect of 7
Subsidiaries.
7 subsidiaries of Coal India Limited. Stop. In the organization where the petitioner is serving, he is at serial number 454.
That was the submission, my lord.
4. Stop.
5 to 18.
Though the list of
serial number 5.
5, not 4, but 5. Though the list of recommended candidates was published on 15th March 2026, but the same could not be implemented immediately due to the model code of conduct which is prevailing in the state at the moment on account of the West Bengal legislative elections, 2026. Stop. It has been submitted that promotion will be given in given by maintaining the serial in the combined list of promotion. Stop. There are other employees senior in rank to the petitioner who are liable to be promoted earlier than the petitioner. Stop. The necessary clearances have been received and the list will be given effect to
After consideration of all the documents.
After consideration of all necessary documents. Paragraph. I have heard the submissions made on behalf of both the parties and have perused the documents placed before the court. Stop. It appears that the petitioner is indeed recommended for promotion. Stop. The list of recommended candidates was published on 15th March 2026 and the authority intends to give effect to the same by maintaining the serial of the candidates in the list. Stop. The in usual course, the petitioner will attain his date of superannuation on 30th April 2026. Stop. A writ of mandamus cannot be issued commanding the respondents to give immediate effect. Respondents to give immediate effect to the list of recommended candidates, the authority is required to obtain the necessary clearances and to follow the model code of conduct which is prevailing at present. Stop. The authority will take steps to give effect to the list of promotion at the earliest by maintaining all formalities. Writ petition stands disposed of.
If if possible, in 3 days they can.
No, sir, this mandate is not possible to give.
If in the meantime, Lordship, I superannuate, Lordship, I may be given liberty to approach for Lordship
Notional
release at that point of time. Lordship.
notional benefit without functioning in the promotional post. Sorry, sir.
Lordship,
Yes.
give me that liberty, I'll take
No,
my chance.
sir, because this is going to give rise to further litigation. Yes.
My lord, with all humility, my lord, I submit today that this is that matter, my lord, in which we were
I
assisting.
can see the recording in the earlier order
Yes.
that your client has
Well,
withdrawn
yes,
the
this-
pending indents.
Yes, now this was very surprising. Well, I ought to have disclosed this. I have taken instructions, my lord. Kindly see that document which I have borrowed today in court from my learned friend.
Hmm.
My lord, this he says he has got no, because this has been done by some other person who was there. Nothing to do with him, my lord. Some Mr. Mukherjee scribbling is there. We know, my lord, the little bit of company law that it's the director or the board has to take a decision like this because this is a pending litigation. I am
No,
responsible.
no, it is you. They have not taken
No,
any
that's why
decision.
it is. When my lord was given the impression it's not the director or a person authorized to take decision. It's a person, my lord. I called that person.
Which person?
This
Your
is-
client?
This is Mr. Mukherjee, my lord, who is the client. Who, if my lord says he is the client, my lord, I will say no, because as an officer of court, I ought to have been given this opportunity to present this document. This is not done. I have taken steps against this person. I have advised the client to take steps because well,
But
this,
with these disputes,
no,
how can the
cannot
repetition
be possible. Not possible. So well, and after all, contempt is a matter between the court and the contemptor.
Yes,
I
yes.
can only think, because if this letter is kept, either well, this is only my humble submission as an affidavit opportunity, because I have spoken indirectly to my learned friends also. An explanation may be given to me if my lord thinks. If my lord doesn't think, my lord, contempt, my lord
Can be disposed of.
so
Nothing
far as the writ
remains.
petition is concerned, my lord, kindly give me an opportunity, my lord, to explain this and kindly fix it after the elections are over, my lord. Because I have to take specific instructions. I cannot, my lord, leave it like this, because this is something which is very
Because
dangerous.
this is your internal affair between your
My lord.
company, right?
My
Why will the writ petition be pending for this?
My lord, no, if it is because of one simple reason, according to my humble submission, this is a very serious matter. This is not a very internal.
Serious matter between you,
No, between the court.
your
No, because
client,
as an officer of the
your-
court, I ought to have been given the opportunity. to
doesn't matter.
discuss.
I take this on record and I dismiss it. And you take steps in respect of whoever Mukherjee or whoever is there.
Madam,
Nothing
kindly
remains
dispose
in
it
the
off.
writ.
Madam,
Deeply grateful, Lord.
contempt dismiss
Please
it.
come.
But
The
yes,
writ also I'll dispose.
yes, very.
The- On hearing the submission made on behalf of both the parties and on the documents placed before this court by the learned advocate representing the contemners, comma, the court is of the considered opinion that after the pending indents have been withdrawn by the petitioner company, comma, nothing remains to be decided either in the contempt or the writ petition. Stuff next. In view of the above, both the contempt as well as the writ petition stands dismissed.
Deeply grateful, Lord.
All connecting application stands dismissed.
May my lord's pleasure is to use the word dismissed rather than disposed of.
No, how can I?
No, that's the only prayer. Well, that's why I wanted the prayer for affidavit.
Sorry,
Which,
sir.
very well, my lord. It's
Yes.
entirely my lord's. Deeply obliged, my lord. Deeply obliged.
Deeply grateful, Lord.
Is that matter, milady, whereby the judicial officer has been terminated and we had challenged the disciplinary proceeding itself vis-a-vis the order of termination, milady. Last occasion, Mr. Mojumdar was about to conclude our submissions, milady. This is the note which was prepared by our side.
Yes.
So I have already placed the entire thing except for the judgments, milady, for the purpose of
On behalf of state, your lordship. That was Mr. Mukherjee.
So I have already placed the jurisdictional error so as to the disciplinary authority, which is the full court, who has not taken the decision. Rather, the administrative committee consisting of the 6 honorable judges has taken the decision for the purpose of initiation of the disciplinary proceeding vis-a-vis the order of termination also. Thereafter, milady, the charge sheet which was issued by the Registrar General of this honorable court, which was also again the error of jurisdiction, since the charge sheet can be issued only by the full court, not by the Registrar General, which has been held in our case only, the Ananya Bandyopadhyay's case. Thereafter, 3 is the inquiry officer appointed even before issuance of the charge sheet on 22nd of September 2021. I have already placed in terms of the rule 11.4, the inquiry officer was appointed on the date when I was issued about the charge sheet, milady. Thereafter, 4, the administrative committee decided to suspend and initiate disciplinary proceeding. Again, the jurisdictional error, since the administrative committee is not the appropriate authority, rather the full court is the appropriate authority. Now, milady, on merit, I have already placed that these are all at best the error of judgment which can be considered, milady. Or at best, it can be said that the order of the Supreme Court, which was placed before me in a later stage, I was not aware about the fact of the dismissal of the Honorable SLP in the Honorable Supreme Court. 2 says the findings in the inquiry report are beyond the imputations of the misconduct. I have already placed that the charges which was given to me was in effect was vague. Thereafter, I have already made an application before the disciplinary authority, which is on merit 3, that my entire case record may be placed before this honorable court, which was again rejected.
Entire case record be placed before the
Disciplinary authority, before the inquiry officer. Let it kindly takes up
Oh,
the...
that was rejected.
Yes, that was
you
rejected.
placed,
Yes.
right.
Thereafter,
And
so,
placed by an order of court. It was a judicial order.
judicial order, yes. The entire file which was before the learned court below, I filed an application before the inquiry officer, bring the entire file in terms of the rules of 2007, which application was also rejected. Thereafter, the Judges Protection Act I have already placed. In the chief also, I have specifically said that I received the order of the Honorable Supreme Court in a later stage, milady. Thereafter, the execution of warrant, which was known when I was made aware about the fact of dismissal of the Honorable Supreme Court order, I immediately issued the warrant of arrest. Page 3, columns 8. In cross-examination also, I have replied that I passed the order mentioned in the charge sheet before receiving the order of the Honorable Supreme Court. Lastly, no so-called notice was given to me in violation of the Rule 11.19 of the Rules of 2007, which says that what is the proposed punishment, which was not even also given to me. Thereafter, the judgments which I have already placed, the first judgment I have already placed to show that the charge sheet issued without granting any opportunity to the petitioner, which is infraction of the rules of 11.2bi of the rules of 2007. Second proposition to this judgment only, that inquiry officer was appointed without considering the written statement of defense to the articles of charge. I have already placed that on the day, very same day, the charge sheet was issued to me. On the same date, the inquiry officer was appointed without even considering my written statement of defense. The second judgment which I have placed with regard to Mintu Mollik judgment, which says the lack of jurisdiction of the administrative committee and the Registrar General is not the competent authority to draw up the charges. And the second proposition in this judgment only, that says an error of judgment does not per se constitute misconduct. Third judgment which I have already placed, that merely because the order is wrong or the action taken could have been different, does not warrant initiation of the disciplinary proceeding against the judicial officer. The fourth judgment is the inquiry officer is not permitted to travel beyond the charges, and the punishment imposed on the basis of the finding, which was not the subject matter of the charges, is wholly illegal. Now, milady, the 5, 6, and 7, these are the 3 judgments which I want to place. Thereafter, I'll conclude my submissions, milady. The 5th judgment is 1970, volume 3, SCC, page 548. ঠিক আছে। It is the para 6 of this judgment, which says that now in the present case, each charges was so bare that it was not capable of being intelligently understood and was not sufficiently definite to furnish materials to the appellant to defend himself. It is precisely for these reasons that fundamental rule 55 provides, as stated before, that the charge should be accompanied by a statement of allegations. The whole object of furnishing the statement of allegation is to give all the necessary particulars and details which would satisfy the requirement of giving a reasonable opportunity to put the defense. So my case is that the charges was that you passed a wrong order at best, which also does not say in the charge sheet. In the statement of defense or in the inquiry report, it was clarified that you were supposed to issue the warrant of arrest, which you could not issue in the first instance. Thereafter, you have issued. So the time infraction is there. Only that is the sole charges against me. Thereafter, the second sixth judgment, 2022, volume 13, page 1. Para 56, 58, 59, 67, and 68. Para 56 is at internal page 30. We are in agreement with ratio laid down in so and so that every judicial officer is likely to commit mistake of some kind of the other in passing orders in the initial stage of his service, which a mature judicial officer would not do. However, if the orders are passed without there being any corrupt motive, the same should be overlooked by the High Court and proper guidance should be provided to him. Even then, there is no allegation of corrupt motive in my case. Thereafter, para 58. In this context, it is pertinent to refer to the standing order so and so. The complainant making allegation against the members of the subordinate judiciary in the states should not be entertained and no action should be taken thereon, unless it is accompanied by a duly sworn affidavit and variable material to substantiate the allegations made therein. So it was one of my point that the complaint letter, which was firstly placed before the Honorable High Court, that was not sworn by any affidavit, though already it was been clarified by them in their opposition that the complainant is the genuine person. Thereafter, para 59, in the present case, the record clearly showcases that no variable complaint was filed against the appellant that could form the basis of the disciplinary proceeding against him. Thereafter, para 67, Placitum E. It says, a 3-judge bench of this court in so-and-so case has specifically held that this court on several occasions has disapproved the practice of the initiation of disciplinary proceedings against officers of the subordinate judiciary merely because of the judgments order passed by them are wrong. The appellant and revisional courts have been established and given powers to set aside such orders. The higher courts, after hearing the appeal, may modify or set aside the erroneous judgments of the lower courts. So it was my case that my order was never tested before any higher authority. If they are so aggrieved by my order, they could have tested before the higher authority. Thereafter, para 68. Para 68, last line. If the High Court was to initiate disciplinary proceedings based on a judicial order, there should have been strong grounds to suspect the appellant's bona fide and the order itself should have been acquitted by malice, bias, or illegality. This is clearly not in the case in the present matter, exactly my case. The appellant was competent and well within his rights to grant bail to the accused in discharge of his judicial functions. So there is no allegation of my corrupt motive. There is no allegation of malice in the charge sheet, not in the inquiry report, not in the disciplinary proceeding entirety. And the last judgment, 1990, page volume 7, page 409. The proposition is that initiation of disciplinary proceedings against an officer cannot take place on information which is vague or indefinite. There must exist reasonable basis for the disciplinary authority to proceed against the judicial officer. Para 43. If every error of law were to constitute a charge of misconduct, it would impinge upon the independent functioning of the quasi-judicial officer, though it is upon the quasi-judicial body, here in the judicial officer's ability. Since in the sum and substance misconduct is sought to be inferred by the appellant having committed an error of law, the charge sheet on the face of it does not proceed on any legal premise, rendering it liable to be quashed. In other words, to maintain any charge sheet against a quasi-judicial authority, something more has to be alleged than a mere mistake of law. That is in the nature of some extraneous consideration influencing the quasi-judicial order. There is no allegation to that effect. Since nothing of this sort is alleged herein, the impugned charge sheet is rendered illegal. The charge sheet, if sustained, will thus impinge upon the confidence and independent functioning of the quasi-judicial authority. The entire system of administrative adjudication, whereunder the quasi-judicial powers are conferred on the administrative authorities, would fail into disrupt the officers performing such functions are inhibited in performing their functions without fear or favor because of the constant threat of disciplinary proceedings. Exactly my case. There was no allegation of corrupt motives. There is no allegation of any malice. At best, it is an error of law, which was again not tested before any higher authority. These are my submissions, lady. I have already placed. Sorry.
I would like you to start on the next day.
Whenever.
Next
Could we come back next week, Lord, Monday?
Monday or what?
Tuesday, whatever.
Tuesday, I'm told.
Much open.
Learned advocate representing the petitioner concludes argument. List on 5th
Much open.
for hearing the respondents. No further.
For the petition.
The writ petition has been dismissed. The details of the order will be put up in the server immediately. Grateful, my lord. Why to be mentioned?
Because when the last occasion, it was directed upon the respondents to file affidavit in opposition.
That has not been filed.
My lord, I am appearing for the respondent in this matter. My lord, affidavit in opposition is ready. My lord, only due to this some difficulty, it could not be signed. Kindly give me this week's time, it will be filed immediately.
All right, please come. On the prayer of the learned advocate representing the respondents, time to file the affidavit in opposition stands extended till 6th May 2026. Reply, if any, may be filed 2 weeks.
1 week.
22nd May. What is the matter about? Disciplinary
My lord, it is
proceeding?
a disciplinary proceeding. My lord, a minor punishment was there, my lord, which was inflicted.
Which authority?
RPF, my lord. RPF.
All right. List for hearing in the combined monthly list of June.
Public. Same, my lord.
It is identical.
Same party, I see.
Same party,
Same
two
party,
separate
two
disciplinary
separate proceedings, and my lord, in one the punishment is almost gone, my lord. 6 months only the promotion has been struck without any effect.
Two separate.
Same order.
Public.
Given the naam de.
But I beg to appear for response for this report, my lord, that I could not file earlier. My lord. Here, my lord, the petitioner had asked for, my lord, employment. He is the indirect dependent, my lord. He is the son-in-law. Now, my lord, we have passed and regent order, my lord. Where, my lord, we have rejected it, my lord, under 2 grounds, my lord. Mainly 2 grounds. First, my lord, when the marriage was taken place, my lord,
Whatever, the ground, he'll challenge it afresh. Please
No,
come.
I am not challenging, my lord.
You challenge it
I'm not
afresh.
challenging. I am accepting this.
Oh, you accept
I'm
it.
kind of, one direction is required from your lordship, which I am asking for. But kindly come to page 21.
Yes.
I'm accepting this. The last but first one paragraph, last but one. Accordingly, the claim of Sri Fulchand Hembrab so and so is rejected. I do admit. The unit authority, Kajora area shall process and extend MMCC benefits admissible under so and so to the widow late Laldo Mardi. Now we are accepting this, but let there be a direction to expedite this. Because they didn't take any steps since 2013.
All right, please come.
But I don't object.
Report filed. By the respondents. In court today is taken on record. Stop. It appears therefrom that the authority rejected the prayer of the petitioner for grant of compassionate appointment by passing reasoned order on 16th April 2026. Stop. The reasoned order is annexed to the report. Stop. It appears therefrom that the authority that at the time of rejecting the prayer of the petitioner, directed the unit authority, Kajora area, page 21, to process and extend monthly monetary cash compensation benefit admissible under NCWA to the widow of the employee, being the lawful direct dependent. Stop. Learned advocate for the petitioner submits upon instruction that the petitioner does not intend to challenge the impugned order of rejection. Stop. Prayer has been made to direct the authority to take steps in terms of the conclusion arrived at by the authority at the time of rejecting the prayer for compassionate appointment of the petitioner. Stop. The paragraph. In view of the above, the instant writ petition stands disposed of by directing the unit authority
Direct the general manager, Kajur area, my lord.
Respondent number 5.
Unity authority, my lord.
Respondent number 5.
Respondent number 5, my lord.
Being the respondent number 5, the general manager, to process and extend MMCC benefits admissible under NCWA to the widow of the employee at the earliest without any further delay. Stop. The authority shall ensure that the benefits, as admissible, are released positively within a period of 4 months from the date of communication of this order, subject to compliance of all necessary formalities. Disposed.
Great.
Grateful.
Well, I am for the respondents.
Here for the petition. Item number 6, I am for the state law. My lord, service and notice.
Where from? Regulated Market Committee of
Nodia Jilla regulated.
Nodia.
Nodia Jilla regulated. My lord. Everybody has been served, my lord, and put on notice, my lord. My lord, the petition.
West Bengal State Agricultural Marketing Board.
My lord, I am going.
All right. Yes. What is the issue?
My lord, the petitioners, my lord, initially, my lord, was appointed as, my lord, a civil defense personnel with QRT, quick response team, with the DM, District Magistrate of Nodia.
State who's there?
My lord, served, my lord. I am for the state, lord. Yes. Thereafter, my lord, kindly come to page 42. A requisition has been made by the concerned regulated market committee, Nodia Jilla Regulated Market Committee, page 42, my lord, kindly come to.
Yes.
To the district magistrate, Nodia. My lord, district magistrate is also the chairman of the, my lord, regulated market committee. It says engagement of civil defense QRT personnel at different checkposts and sub-market yards at Korimpur.
What is the date? 2016?
16, my lord.
All right.
16. They say, my lord, we have 4 number of checkposts in different places and 1 market yard, Korimpur, run with the 6 numbers of NVF personnel and 23 numbers of private security personnel for the security round the clock. Now we are keen interest that the checkpost of submarket yard run with the civil defense personnel in place of NVF and private security personnel on and from December 16, 2016 with minimum allowance. In this regard, I would request to arrange for the civil defense QRT personnel as the following details. Details have been given, my lord. Thereafter, my lord, kindly come to. Thereafter, my lord, 25% civil defense personnel with QRT training. They have been sent to the, my lord, Nodia Regulated Market Committee to work under the Nodia Regulated Market Committee. My lord, now kindly come to page 48.
No, page 44 onwards is the
name of the
volunteers list where these persons engaged.
Yes.
Then
engaged by the Nodia Regulated Market. Thereafter, kindly come to page 48. This is the deployment order issued by the Secretary, Nodia Jilla Regulated Market Committee. And my lord, remuneration was fixed at rupees 5,900 per month. The petitions, my lord, are round the clock, my lord, serving for the Nodia Jilla Regulated Market Committee. They are being paid by the Nodia Jilla Regulated Market Committee in their account directly, not by the district magistrate from the end. Or, my lord, they are, from their honorarium or the salary, whatever the name they called, employees provident fund have been deducted by the Nodia Jilla Regulated Market Committee. That is amount, my lord, 708 per month. And that amount, together with the amount of the employer, is being deposited with the
EPF authority.
And my lord will find.
What is your grievance?
My lord, my grievance is, my lord, we are getting, my lord, 5,900 per month. Out of that, 708 rupees is being deducted PF. We applied before the Nodia Jilla Regulated Market Committee that there are government notification whereby, my lord,
enhancement of remuneration. 9008.
Following that,
2011.
current is, my lord, 2024
January.
Yes, we sought for that particular remuneration on the basis of
that has been rejected.
That has been ordered by the Honorable Court to consider by the respondent.
Right now, rejection is under challenge.
Yes.
All right. That is page 86.
Yes.
6th of November 2025. What is the ground for rejection?
They say, my lord, we are not
applicable.
Not applicable. We are not the employees. My lord, when there is clear establishment of, my lord, employer-employee.
Well, it has to be decided. Please.
My lord, another thing, my lord. The Honorable Court passed order directing the respondent number 2, that is the board, to decide the issue through a authorized officer or representative. I find, my lord, the chief executive officer is not been authorized by the board to decide, because as per the act, my lord, the board is the competent authority to decide all the issues. And my lord, after the order being passed, I wrote an email asking the chief executive officer whether any authorization has been done by the board to deal with this matter by the chief executive officer.
But then I do not understand how can the chief executive officer or whoever from the board can decide the issue. This has to be decided by the finance department, and this court is passing regular orders as to whether the finance department memo will be applicable to these
They
people
applies.
or not.
They applies. Board
Who
and
said?
regulated market committee applies. I indicate, my lord, notification. They, my lord, kindly come to resolution of the regulated market committee, page
Please show.
61.
61.
In several matters, my lord, they are applying.
Are the others getting the benefit of this
In other employees are getting.
of the regulated market committee?
Yes.
All right.
Yes.
Then why is it being said that it is not applicable to you?
My lord, kindly come to page 61. It is the resolution of the regulated market committee.
Yes. 25 resolution. What does it say?
Yes, my lord, kindly come to resolution number 4.
Huh?
Board's memo dated such and such, dated such and such, in accordance with the memo dated 1091 PF, that is the latest memo, of 1st March 2024 of Finance Department Audit Branch, Government Officer, regarding revision of consolidated remuneration existing employees should be followed. So
All
they
right.
applies.
So the market committee has decided that it will apply.
Apply.
Then why is it being rejected in your case?
It has been rejected, my lord. Will find astonishingly, my lord, the chief executive officer says we are not the employees. My lord, kindly come to page 87.
You have been appointed by the DM Nodia, Controller of Civil Defense, and only have been deployed for providing security. It is my constructive decision upon perusal of the materials, although the petitioners engaged in the office of the DM and Controller deployed in such and such for providing security. Their services are not recommended as contractual service since they are neither contractual worker or delegated worker in the establishment.
They're giving salary in our direct account at their guidance, my lord. We are working, and my lord, they are deducting PF.
Yes, board. How do you?
My lord, let us come to the initial annexure which has been shown by my learned friend. That is page 42. If your lordship kindly takes the trouble. My lord, these are, my lord, quick response team for engagement of whom, my lord, they were actually requested to be provided. My lord, kindly sees engagement of civil defense QRT personnels at different checkposts and submarket yard, Karimpur. So, my lord, thereafter kindly turns to page 43. Now, 43 actually gives us the deployment of civil defense QRT personnel, which your lordship has just pointed out. My lord, there was a list of people who has been otherwise given this. And these are all, my lord, civil defense volunteers. They are volunteers, my lord. They had undergone that training and they are the volunteers. Now, my lord, the particular notifications, the benefit of which they are wanting to seek, if your lordship kindly takes the trouble to turn to page 55. Well, this is the first one. This is only applicable in cases of those companies or, my lord, units which was otherwise had to be restructured or wound up. Now, this is not the case of this particular persons who has been engaged. And it is also not a case of redeployment. So, in any event, my lord, this notification doesn't stand its field. That's the first thing. If your lordship kindly turns to page 55, may I just read? With a view to ensuring the optimal use of public fund and to use the available manpower in...
No, don't read this.
So, my lord, this is the one which they were harping on. The next thing, my lord, which follows, my lord, is with respect to the other notification, that is 1st of March 2004. My lord, whether they are coming within the purview of casual or contractual or engage in various government and establishment. My lord, this is also not coming. And the letter which they have shown, my lord, that is with respect to sweepers.
Which one?
My lord, the one which has been placed before your lordship.
Yes.
Yes, my lord.
Page 61.
Page 61. My lord, kindly sees.
This is in respect of sweepers appointed as contractual.
No, 5 is the for the sweeper, those who have been, my lord, part-time.
My lord, sweeper is a different thing. These are civil defense volunteers.
5
And
is
they
for
were
the sweeper.
engaged based on the that particular letter seeking to engage. And my lord, the unit from which they were actually given the deployment, that it is not a redeployment case. So they cannot take the
No,
benefit
no,
of
no.
that.
This is not a case of redeployment. Thing is, they are working since
It is
2017
a fact.
possibly.
My lord, this is something which I also asked my learned advocate on record. My lord, let us come back with an opposition, and my lord, your lordship decides it. Because in any event, what is going in your lordship's mind is that it is 2017, 2019 onwards, and these are the persons who are getting only 5,900.
Right.
That is perhaps which is striking your lordship.
Certainly.
Well, let us come back. Let someone take the onus why they have passed this order, and then we can argue. With respect to whether this person had the authority, my lord, we have an authority letter based on which this person was given the authority. So that is something which is already taken care of. So based on that, my lord, this order was passed. So this is what it is. Whatever notifications they have sought, they have strictly actually relied on two
Please come.
notifications,
My lord,
which doesn't hold field in this.
The order dated
my lord, if comes
6th November 20. Let them come. November
fixed date, my
2025. Passed by the Chief Executive Officer,
in the
West Bengal State Agricultural Marketing Board, allegedly in compliance of the direction passed by the court on 30th June 2025 in WPA 1346 of 2025 is impugned in the instant writ petition. Stop. The prayer of the petitioners for enhancement of their remuneration has been rejected by the authority. Stop. The jurisdiction of the officer passing the said order is challenged. Stop. Paragraph.
Well, may I just hand over that?
No, please. To adjudicate the legality and validity of the order impugned, a report from the West Bengal State Agricultural Marketing Board would be required. Stop. Paragraph. Next. In view of the above, the board is directed to prepare and circulate a report by way of affidavit. How soon can you do it?
My lord, post-election at least my 4 weeks, my lord, but
By 21st of May.
21st.
Exception, if any, may be prepared and circulated by 12th June. Liberty to mention the matter for hearing immediately on completion of the aforesaid time period.
Much obliged, your lord. Must.
Service taken on record.
It is very much astonishing.
The finance department shall also file a report specifically mentioning as to whether the notifications memorandum dated 1st March 2026. It's 1st March, isn't it?
Yes, my lord.
2026 can be made applicable in case of the petitioners. Within the time limit, or you can file a report within the time limit stipulated herein above. Please do that. State.
Notes.
Much obliged. And my lord, also to serve an advance copy in the event they have done it. Because we'll also get a note of their stand. Because if they say yes, my lord, then things become much more easier. Much obliged.
And nowadays, my lord.
Next.
Yes.
Even may I please lordship, I am for the petitioner. This is my affidavit of service. Here what happened, my lord. The petitioners before your lordship, they have approached earlier before this honorable court, challenging the shortfall of their height of 169.5 and less, 65 and less. My lord, they preferred appeal. Appeal did not consider approach before this honorable court. This honorable court was pleased to direct the respondent authority to remeasure their height. They, the respondent authority considered, remeasured the height and allowed to participate the DV, document verification, detailed medical examination. They all found fit in all examination. That is on 24th January 2026. Although result has been published on 15th January 2026. This petitioner approached before the respondent authority concerned. All the other candidate has given recommendation and appointment, but this petitioner was not yet been given
And your
recommendation.
name is not in the withheld list or
Withheld it
nothing.
because after publication of result, they have my lord, complied with the Honorable High Court's order. And
All right, what
found
is your stand?
He has annexed. I do not have any instructions on this
Take
matter.
instruction.
Yes, sir.
Do
But
not
one
make
thing, my lord,
impromptu
there are
submission.
1, 2, 3, 4 petitioners, my lord.
Huh.
Only in respect of one petitioner, they have annexed
Annexed
the
documents?
Yes, my lord.
Others they have not?
I have annexed all the documents. Kunta bole?
Najmul.
Yes. What for that?
Shubho Mondol.
Everybody's documents are there, man.
Check up if all annexures are there.
DME, that is in the DME they have found fit. Only one person has preferred review medical examination. That's why the medical document has been annexed. Otherwise, is those who found fit in detailed medical examination, they have not been given any documents.
The height is so high.
You take instruction.
Medical করে দিয়েছে আবার height এ কি?
The petitioner has
See the
participated for recruitment in CAPF examination, 2025. Stuff. They claim to have cleared all the stages of recruitment. Stop. They allege that they are not being provided their letter of appointment and no reason for the same has been made known to them. Stop. Learned advocate representing the respondent seeks time to revert with instruction. Stop. Let written instruction in the form of a report be placed before this court on the adjourned date.
Kindly takes up in earlier basis, urgent basis, otherwise.
After 4th.
After 4th. 4th is next Monday, is all right. After 4th is all right. 12th May.
Much obliged. Grateful to Lord.
Services.
The only issue is that the tests were all conducted after publication of the.
Yes.
Oh,
In case you find there is any document missing, get
Yes,
in touch with your friend. He'll provide you with all the documents.
But only one, they have the petition number 1 has been detailed medical instance found unfit. That's why this document has been provided.
I have understood.
Otherwise,
next.
Much obliged.
My lord, I appear for the respondent bank.
For the petitioners, I have applicant of the personal account appointment, Punjab National Bank.
Under?
Punjab National Bank.
All right, yes.
My father died on 31st July 2018. And I have applied for the compulsory appointment on 24th June 2019. Because some proceeding is there, the branch manager has wrote a letter that there is a scheme for compulsory appointment, you can avail it. And then I have availed for the put up the application on.
Your prayer has been rejected on the ground of non-fulfillment of educational qualification and the income criteria.
The final rejection, please.
Page.
Page 132, they are challenging.
140?
132, my lord. The last annexure P19.
Number 132.
Yes. Final closure of compassionate appointment. Financial eligibility threshold 60% of the is absolute. Any excess irrespective of renders the case ineligible.
It is absolutely wrong proposition.
How much is your
10,235 10,235 family mention I am getting. And the last paid one was 28,620.
All right.
If the 60% is calculated, then it will be not under purview of the 60% of the gross salary. It will not come down.
You are the son.
Yes. One thing, my lord, I have applied on 24th January 2019. And that rule was prevalent at the time of the death or application, there was no any bar of the threshold limit of the income criterion. The income criterion was amended in 2020. So how it will be applicable to my application?
Please come.
Malon, only one.
Are you ready
Malon,
with
this-
instructions?
Yes, Malon. When this issue has already been decided by a coordinate bench of this court, and Malon, they did not prefer any appeal. Malon, the order of the bank, Malon, Malon kindly comes to
Where
page,
is the order
Malon,
dated
page number
18th
92. Malon,
18th
yes,
of November
1811.
24?
Yes, Your Lordship. Malon, after a detailed argument, Malon, the order passed by the bank was affirmed, Your Lordship.
Page.
Page 92, Your Lordship.
92.
92.
Where is the income criteria issue gone over here?
Malad, at that point of time, Malad, they have challenged the order of rejection. That was Malad of 28, Malad of 16th. But at that time, Malad, they have challenged the order of 16th April 2022, Malad, which was only for the educational criteria.
How can you segregate it? One's educational qualification,
this-
one income criteria, it
Malad,
cannot be.
thereafter, they has once again, Malad, applied before the bank, Malad. Malad, this is the third round of litigation. Malad, at first they have come before your this honorable court. Malad, this honorable court, Malad, passed an order that the order was a cryptic one.
Page 92, the order that you are relying upon the judgment.
Lordship.
Does this take into consideration the financial income criteria?
Malad, yes, that was also
that.
there. Malad, that was also there. Malad, that is at page number. Malad, the rejection.
Page 93.
I'm coming to the Lordship. Malad, the rejection, what they have challenged there is at page number 89.
Please come to
No.
paragraph number 6 of the judgment.
Lordship.
There is a mention regarding the income of the family from all sources less than 60%.
Lordship.
Right?
Yes.
There is nothing with regard to the court's finding with regard to the family income.
My lord, at that point of time, I argued. My lord, once again, I'm arguing. My lord, he has his younger brother named Suraj Basfor, my lord, who is having an income of 46,000 and more, your lordship. My lord, only thing that by affidavit, Suraj Basfor is stating that no, he is dependent, the parents are dependent on this son, Rajesh Basfor. My lord, only this thing. And my lord, they could not substantiate that before the honorable court. My lord, I can show, my lord, the income of the Suraj Basfor, that is also there on record.
Please come.
Sir, please, my lordship, you come as a page
The
number
order
31.
dated 10th November 2025,
My lordship,
dismissing the prayer of the petitioner seeking compassionate appointment on the ground that the petitioner does not meet the financial eligibility threshold.
no, there is no question at all. My lord, there was no question at all at the time
Just
of
wait.
application.
Please wait. Threshold of earning 60% less than the last drawn gross salary of the deceased. Stop. The according to the petitioner paragraph, you have your mother.
Yes.
Yes.
The widow earns family pension of rupees 10,000.
235.
235 per month. Stop. Apart from the above, there is no other income of the family. Stop. The younger son of the deceased, that is the brother of the employee, resides elsewhere and does not take care of the family.
Yes.
Stop paragraph. Learned advocate representing the bank submits that the issue of compassionate appointment has been conclusively decided by the court in the earlier writ petition filed by him. Vide judgment dated 18th November 2024
and no appeal preferred
in WPA 13469 of 2022. Stop. The petitioner cannot raise the issue all over again. Stop paragraph. On a perusal of the judgment delivered by the court on 18th January 2024, it appears that the court took into consideration the educational qualification of the petitioner for his entitlement of appointment on compassionate ground. Stop. The issue of financial income of the family in excess of the minimum threshold was not before the court. Stop paragraph. To ascertain as to the calculation which the authority relied upon to reject the case of the petitioner, the bank is directed to file a report disclosing such calculation. Stop. Such report shall be prepared and circulated by 21st May. Release the matter on 15th June. It will be open for the petitioner
May it will be
to prepare an exception to the report filed by the bank prior to the adjourned date.
Grateful, my lord.
my lord. It will be very clear. It earlier to 21st May.
Why?
Earlier than 21st May.
Why?
Because I will not be go to the medical.
I have to
checkup.
file my report. Matter is in month of June.
Who will file go for medical?
I-
Come back in June. Next.
Grateful, my lord.
Grateful.
Yes, please.
Single petitioner.
That
this is the order of your lordship, but the only difficulty here is that I joined the post.
Is
and
the hey, ma'am. Yeah, thanks.
কি বলছে? এটা কেন রাখছেন আপনারা? এটা রাখছেন কেন? Yes, please.
But this is my affidavit of service, single petitioner. But here the only difficulty is that the moment I joined on 16th of December 2025, but I got leave for my pregnancy, and I'm still on leave. I have given the birth of my first baby on 11th of January. So I could not make the application or representation. With your lordship's leave, which my lord has granted in Dolly Rajbangshi's case, I have handed over to your lordship. I will make a fresh representation and let them consider.
Why did you come to court? You could have made their representation
In
directly.
June, it will be over. The leave, the maternity leave will be over by June.
Yes.
So I will be not in a position to make the representation as I am in Malda and I have not joined my post. Present place of posting, only one day I joined. Thereafter, I have gone to my native village for my delivery. So I could not make the application. And my baby is only 2 months old.
Nothing to do with the baby. Thing is, If you want to make an application before the authority, you can always make it. Why?
Absolutely.
Come
But the physical condition was not so good of the
now
petitioner.
it is better.
Now it is better. My lord, so
Go
if,
there.
if
No,
your
this
lordship,
is not entertaining at all.
my lord, your lordship has granted that power, my lord, the liberty, my lord, to the petitioners.
No, no,
My lord, your
cases-
lordship kindly.
It varies from case to case.
Yes, but my lord, your lordship has in Dolly Rajamokshi's case, my lord, in paragraph 15, my lord has granted leave, my lord, to each the petitioner will forward separate applications highlighting their grievances with their prayer, disclosing their position.
The petitioner is serving as health assistant within bracket female in the Department of Health and Family Welfare, Government of West Bengal. Stop. She is currently on maternity leave. Stop. Paragraph. She alleges that she has been posted in a very far off place. Stop. She seeks posting to a place which is close to her residence. Stop. She has given birth to her first child in January 2026. Stop paragraph. It will be open for the petitioner to apply before the authority. Seeking, no, not seeking, apply before the authority, highlighting her grievances with her prayer.
Great.
Stop. On application being made, the same shall be considered by the competent authority in accordance with law.
I'm grateful.
Nothing mentioned. Take this to back. Service is taken on record.
Disposed of.
Yes.
At 10, there are two petitioners. But here, we are working since 2022, more than 3 years.
Who's your other side?
But this is my affidavit of service. I made a kindly turns to the interesting part, page 37 and 38. But the RTI information I obtained for the district of Dakshin Dinajpur, page 38. Well, there are page 39, there are 65 vacancies. Well, we are from Dakshin Dinajpur. Well, 4 years, well, we are discharging our duties in Murshidabad and Uttar Dinajpur. So, well, we made a representation. Well, if your lordship kindly directs the authority to consider, because it is more than 3 years. 3 years bar, and now we are working since 2022. May I hand over the judgment of your lordship?
No. And how many court fees have you paid?
No, one. I will pay the second one. Two petitioners are there.
2 petitioners have approached before this court
Acted
by depositing only 1 court fee. Stop. Learned advocate on record of the petitioner is granted leave to deposit the deficit court fee in respect of 1 petitioner in the course of the day. Stop. Paragraph.
Without my lord's order, it will not be possible. It requires my lord's order. Right?
Why?
Your lordship's order is required by the department. We have to write it down. That in terms of your lordship's order, we are depositing the court fee. Then only they receive the court fee.
And not even online payments are also not.
Online, same process.
The court's order is required
Yes,
for
yes,
online payment.
Yes.
By course of tomorrow.
Achha.
The petitioners are serving as health assistant
Female.
within bracket female under the Department of Health and Family Welfare. Stop. They are serving in the district of Murshidabad.
No, Uttar Dinajpur.
Acha, in Uttar Dinajpur. Stop. They are the permanent residents of the
Dakshin Dinajpur.
district of Dakshin Dinajpur. Stop. The petitioners have annexed document in support of the submission that there are several vacancies which are available in the district of Dakshin Dinajpur. Stop. The petitioners pray that their application seeking transfer to their home district be considered by the authority. Stop. None represents the respondents despite service. Stop. Affidavit of service filed in court is taken on record. Stop. Did you apply?
Yes, yes, yes.
Page.
But it is at page 28.
The application filed by the petitioners seeking transfer to their home district in April 2026. This is Deboshmita. Where is the other one? Page 28 is Deboshmita.
But the other one has not. Deboshmita has done it.
আচ্ছা কি বললাম? The representation, the application filed by the petitioner number 1 seeking transfer to the home district was submitted online on 3rd April 2026. Stuff. The same is yet to be considered. Stop. The petitioner number 2 has not filed any application seeking transfer. Stop. Paragraph. In view of the above, the instant writ petition stands disposed of with the observation that it will be open for the petitioners to file application seeking transfer to their home district.
Grateful.
In the event such application is made, the same shall be considered by the which respondent was directed? Director?
Director of Health Service.
Director of Health Services,
Yes.
Nursing Branch, being the respondent number 2 herein,
2.
to consider and dispose of the prayer of the petitioners in accordance with the prevailing guidelines at the earliest, but positively within a period of 6 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to the petitioners immediately thereafter.
Great. But this is not returnable for the
Why?
to ensure that deficit court is paid.
I believe the learned counsels, the officers of the court. The others where there were 143, 250
I have done it within time. Great.
is expected 200 rupees will be paid by course of tomorrow. Yes, next.
My lord, I am
appearing.
ECL officer.
Petitioner, my lord.
My lord, on the last, yes, my lord. On the last occasion, my lord has directed to file report on behalf of the ECL. And my lord, today report has been ready, but my lord, today it is getting affirmed. Because the concerned officer was engaged for SIR proceedings and my lord, I'm praying for not this week.
Why pray for not this week? Pray for extension of time for filing the report so that he can also file an exception and then the matter can be returnable.
Yes,
Only adjourning for not this week is not the proper prayer. Followed?
Yes, my lord.
On the prayer of the learned advocate representing Eastern Coalfields Limited, seeking extension of time for filing the report, hearing of the writ petition stands adjourned till 18th May. Stop. The report may be prepared and circulated by 30th April. You can do it by 30th. Tomorrow is the only working day. 29th is a holiday. 30th. Exception, if any, may be prepared and circulated by 13th May.
My lord, same matter, my lord. This is a 49 is a pension and gratuity matter. Same petitioner, my lord. Same petitioner, my lord.
Same petition, same.
49?
49.
Are you there?
All our presence
Yeah,
before
for the ECL authority, respondent number 127.
49, please. Just wait, let the file be placed. 49 er file take to bar korun to dekhi. 49. Here also there was a direction for filing an affidavit?
No.
Appearing for the first time?
Not first time.
Not first time.
Earlier it was listed. Last occasion matter was appear, but they are not appear in this matter, my
They
lord.
were not appearing. That is the reason.
Earlier it was listed under the head original site. Therefore, it has been converted to appellate site.
My lord,
The pension and gratuity matter.
from ECL side, we want to file a report. Because
All right.
if they are regarding
Item 49, please record an order. You want pension and you want
Pension, gratuity and provident fund amount.
the petitioner
Is
the
not
widow.
70 years old.
The petitioner is the widow of a deceased employee of Eastern Coalfields Limited. Stop. She prays for grant of pension, gratuity and other terminal benefits Stop. Learned advocate representing Eastern Coalfields Limited seeks time to revert with a report. Stop. In view of such submission,
I am appearing on behalf of Coal Mines Provident Fund Organization. We are the payment authority. Until unless ECL forward claims towards us, we can't make any payment. So we have not received any claims so far from ECL authority.
in view of such submission,
Hearing has
the
already been held.
ECL authority is
before the
directed
mining
to file a report by way of affidavit disclosing its stand by 21st May. Release the matter on 22nd June. Stop. It will be open for the petitioner to file exception to the report prior to the adjourned date. Stop. The Provident Fund Authority will may also file a report disclosing their stand within the time limit as stipulated herein above.
My lord, may I pray to direct the petitioner to produce the original document which has been relied on at
Page number 25A.
page number 25A.
Original
It has been-
document.
It has been addressed to the petitioner from the ECL side, but the Xerox copy not legible letter at all. How we can rely the typed copy of this?
This is the Xerox copy. The original copy is with them. They
It
can
has been
produce the
addressed
same.
to. my
They
lord,
are saying, my lord, I said,
It has been addressed to the petitioner. They are claiming that it has been addressed to the petitioner.
You do not have a copy of this?
the service book, service extra.
You do not have a copy?
Yes,
Your authority must be having copy of page 25.
yes.
My lord, if the relied document is not legible.
Sir, it must be there in your records. Please check up. In case it is not there, write a letter to your learned friend. All right. Call the next matter. আগেরটা item 49 হলো কিন্তু। Yes.
Well, 12 I may applicant.
But I for the state.
Well, this is my everyday service.
কি করবেন?
Respondent number 2.
ও, এই সেটা। তুই বল।
আমি কি বলবো?
Well, here I am challenging the promotional order that is passed by the district judge Paschim Bardhaman. That is, my lord, page 90.
Yes.
And page 90, my lord, given promotion who is junior to the petitioner. Junior member given promotion. One, same date, the date of joining. Another, my lord, the date of joining is 2014. Instead of that, two candidates has been given promotion, depriving the petitioner. Page 90 is the impugn order which is passed by the district Paschim Bardhaman, my lord, district judge. That is my rejection.
Will you be representing the district judge?
No, I am not. On the earlier occasion, Mr. Devjit Mukherjee was there.
Usually, Mr. Devjit Mukherjee appearing for the district judge Paschim Bardhaman, my lord. Usually.
Who are you representing?
Respondent number 2, my lord. Registered General.
Registered General. What about the private respondents?
Private respondent matter as up. Well, they received on 24/4/2020.
Please come. The order dated 22nd December 2025 by the learned district judge Paschim Bardhaman, allegedly promoting the private respondents who are junior to the petitioner by ignoring his claim is impugned in the instant writ petition. Stop. None represents the district judge Paschim Bardhaman. Stop. The private respondents are also not represented. Stop. Paragraph. Let further notice be issued upon the non-appearing respondents. Stop. Hearing of the writ petition stands adjourned till 11th May 2026. Stop.
my lord, same position, my lord,
This is taken on record.
and my lord, abide by the result of the petition because they will, my lord, promotional.
Today, Mr. Mukherjee, you're not appearing.
have not been
Briefed. All right. Let further notice be served. Come back
My
after
lord,
2
same
weeks.
position.
All right, same position.
Yes, grateful, ma'am.
Normally, my lord, I used to appear for the district judge, but where my lord, the copy has not been given, my lord.
Yes.
I am for the petitioner led by Mr. Shubhendu Bandyopadhyay, my lord. My lord, last occasion I have submitted that this is the affidavit of service, my lord. This is the
Srirampur municipality, Mr.
my lord, I have informed, but they have not picked up the phone, my lord, and I have also made a WhatsApp message, my lord. Last occasion, I think his
Nobody
junior
was
present.
He was present.
His junior was present last occasion.
See today. Without the municipality, the matter cannot be decided,
The
isn't it?
claim is against the municipality.
Yes, my lord.
Yes. So
And
the
it's pending
municipality
for
is
long
required.
time, my lord.
My lord, municipality has already paid 4 lakhs.
Already paid, they have paid 4 lakhs. Out of 24 lakhs, they have paid 4 lakhs. My lord,
So
rest
then why
of
is
the
balance not paid? Anything intimated to you?
yes, my lord, they have not intimated to me.
Nothing has been intimated.
Nothing
Acha,
has
please
been
come. None represents Srirampur municipality despite notice.
My lord, kindly consider the
Stop affidavit of service filed in court is taken on record. Consider
representation, my lord, I have.
the petitioner alleges that
38.
out of the total due of rupees 24 lakh, comma, only rupees 4 lakh has been released in favor of the petitioner. Stop. No reason has been assigned for non-dispersal of the balance 20 lakh of rupees.
Page number 40 of the petition, my lord.
The petitioner claims to have
38, starting from 38.
Claims to be a civil contractor and further claims that the said money is due to it on account of the work performed by the petitioner in accordance with the work order issued by the municipality. Stop. It appears that, no, not it appears, in the absence of the municipality, comma, it is not possible for the court to adjudicate the issue conclusively. Stop paragraph. It appears that a representation from the end of the petitioner is pending consideration before the municipality for a considerable period of time. Stop. Next. Without going into the merit of the claim of the petitioner, the instant writ petition stands disposed of by directing the chairman of this Rampur municipality to take a decision on the petitioner's representation, seeking payment of its due amount in accordance with law. After giving reasonable opportunity of hearing to the petitioner for production of all documents in support of the work performed, and by passing a reasoned order. Stop. A decision shall be taken by the municipality at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. If any amount is found due and payable, comma, the same shall be released in favor of the petitioner without any further delay. Stop. Learned advocate for the petitioner is directed to forward a copy of the subject representation along with all supporting documents to the aforesaid respondent at the time of communicating the order of the court disposed.
Grateful.
Grateful.
Tempering was short pass over Mr. Shami Mohammed has been arguing before the division bench. Only 5 to 10 minutes will complete. Only short pass over.
1 minute. Yes, the prayer of the petitioner for leave, study leave this time, has been rejected.
Lord, the earlier prayer was for leave as a trainee reserve.
That is over.
He had taken leave for post-graduation in radio.
Right.
Now, my lord, that was a 3-year period.
Hmm.
Now, my lord, under the provisions, if he has to take leave again as a trainee reserve,
No,
he has to work for 3 years. He has
he
not completed
doesn't,
that period.
he does
But if
not.
he says,
Huh.
I have enough leave accumulated under different categories, and even if that is exhausted, then I'm willing to continue on leave without pay.
No, thing is, the petitioner does not want leave on account of trainee reserve.
Lord, there are one is
Two separate.
now, Lord, under the service rules, Lord, he can take a leave for a maximum of 24 months.
Hmm.
It cannot be under the trainee reserve rules 36 months, and again here 24 months. Lord, he has already taken 36 months. Now, if he wants to take leave without and not use up his leave, other leaves which have accumulated, casual leave, this leave, that leave, plus work without pay, that he has to apply. He has not applied for that.
He has applied for leave.
He has applied for leave, Lord, as a trainee reserve.
No, possibly not,
Lord,
because
please come
that
to-
is what
now,
the
Lord, please come to
submission
your-
was.
Please come to your lordships, the earlier order at page 67.
Hmm.
Study leave, page 48, the first for study leave, application for study leave.
Lord, if he is applying for
It's
study
48,
leave,
Lordship.
now, Lord, there's a maximum period of 24 months.
Hmm.
And he has already taken leave for 36 months and he cannot take it after, unless he works for another 3 years in between.
That is
Lord,
on the
again,
trainee
Lord,
reserve,
the
Lordship.
difference is not as a trainee reserve, he gets all emoluments, all benefits,
In
all
the,
payments.
if he,
He's already done 36 months of that. Then
That-
now he has
that
to
is
work
for
for
the
at least
trainee
3
reserve.
years. The 3 years expires in September.
No, but
September 2026, the 3 years that he has to work compulsorily before applying again works expires.
where is the other order that was shown to me?
page
Just-
94, Lordship.
No, the division benches order?
Division bench, Lordship.
The other order in the other matter.
No, Lordship, that is,
Justice Basak's order or something, if I'm not wrong, was shown.
it is not annexed, Lordship, but I have a hand cover.
Lord,
I have a hard copy, Lordship, that I have not annexed.
I cannot remember the name. Is it Justice Basak's order?
Mudure's Prasad, Justice Division Bench.
This is Boshak, Lordship.
Justice Basak's order.
Another orders, my lord, Justice Prasad.
Is it? It is not annexed.
No, Lordship.
You give a copy to your
I
learned
have already
senior
handed
friend.
over.
Are you aware?
আমাদের তো এখানে তো নতুন মামলা
127
অন্য মামলা
তো অন্য মামলা
এখান থেকে কি করে দেখবো আমাকে একটা কপি দিয়ে দাও কপি দিয়ে দাও কালকে করো
কপিটা দিয়ে কালকে করুন
আমি just use.
Lord, kindly take it up tomorrow, Lord, in that
Not short
I'll have
possible,
some
Lordship.
difficulty.
I have to
But
hand
after
print
2
out
o'clock,
and
Lord, I'll be
Or you give a copy to your learned senior friend because
I'll
this,
come back to Lord,
no,
whatever.
not tomorrow because this matter is being delayed every day.
Kindly,
But after
Lord,
And you
kindly
get
see
engaged
once
somewhere else.
page
After 2
94,
o'clock,
the
Lord,
similar doctor, Lordship, they have also taken the study leave
All
for
right,
3 years.
you give this order to your learned friend. And this, I do not know what it is. You keep it with you, place it formally. I'm passing it over for the time being. Yes.
Lord,
go to
after
next
2
one.
o'clock, Lord, I'm in some difficulty. Lord,
After?
Lord, after lunch, Lord, I'm in some difficulty.
It will be pre-lunch, not post. Yes, next one.
My lord,
EPL.
yes, my lord. On the last occasion, my lord, they were not present, my lord. ECL due to the resolution, my lord, my lord. My lord, what happened, my lord? This is, my lord, employment on the land losers category. Now, my lord, in the meantime, my lord, they called us, my lord, my lord, for document verification. That is done. Medical done. Police, my lord, verification done. My lord, it is, my lord, stuck up in that stage only.
Yes.
My lord, during the process of the case under land scheme, it is not under NCWA, not under service rule. It is a special scheme whose land has been purchased on a fixed rate for giving employment. My lord, during the process, it was detected, though the land has been purchased by the ECL, only on consideration of that time, physical possession was with this petitioner. But they had no right, title, interest to the land. Various documents are there. We have investigated the things from the land department. And
You purchased the land from the petitioner?
yes, but
And the petitioner is not the owner?
no,
What is the value of the
petitioner was not the owner.
Then what remains?
My lord, they have, by giving false representation, they have sold the property in the year 2022. But before that, long ago, the land belonged to different private mines.
Right.
And private mining authority.
How could you proceed to purchase a land from a person who is not the owner?
My lord, that is the question. It is a very, and investigation has been done, and our land, ECL's land, acquired land under Nationalization Act from the private mining
That
authority.
is different. That is not the case. The petitioner claims to be owners.
Yes, yes.
And his case is that you purchased the land from him.
My lord, even after purchase, my lord, you are well, this is the settled things, that even after registration or authority does not go through the title of the transfer. That is the problem.
How could you purchase a land? Registering authority is nobody. He collects the money, it is all right.
Only we have
paid.
At that time,
Who did you pay?
physically petitioner was in possession to the land.
Did you pay the money to?
Yes, that we have paid the money to the petitioner.
Who is not the owner?
Who was not the owner.
What steps have you taken to get the money recovered? Have you taken steps?
Now that we are going now. Process is still, the process is still under pending, my lord. So, my lord, I want to come with
tomorrow. Your land will be sold by your learned friend, and he'll collect the money. What will you do?
I have to recover the money and criminal proceedings both.
What have you done? You've done nothing.
But it is yet to be done, my lord. My lord,
When did the sale
finally
take
give
place?
at least 4 weeks time so that we can come with a complete report.
Milord kindly comes to Milord Kaustubh Mukherjee. Milord kindly see at page 23. He is the petitioner before your lordship. Deed is being executed in favor of the Eastern Coalfield Limited. Now, Milord kindly comes to page 24.
Page 22. This is dated 2022.
Yes. Kindly see page 23.
You
Who
are
is the
Kaustubh Mukherjee,
Kaustubh
where
Mukherjee is the
your
petitioner before your lordship.
record of rights pay you annexed?
Yes. Yeah. Before that, kindly comes to page 24.
24, yes.
Kindly see the last paragraph. And whereas the vendor, keeping in view the circumstances which may render to the said lands uncultivable due to increasing mining operation.
That's all right.
Look,
Show me your record of rights.
Yes, kindly.
Kaustubh Mukherjee, page 21, Danga. Angsho such and such.
Page 18.
Khotiar number 462.
Page 18. There are 2 plots of land.
Please come.
Milord, another thing,
petitioner.
Milord, after Milord filing of the writ petition, my client has got Milord this communication, Milord, from ECL.
My lord, we have details in instruction. It is very lengthy.
File it by way of a report. Somebody should take
Yes,
the responsibility.
yes, my lord.
Because you are alleging crime
Yes,
on the part of the petitioner.
Kindly see, Milord, that document, Milord. This has been
Legal notice. Your queries in respect to the
proposal is under scrutiny from the ECL and
now this has come out in scrutiny that you are not the owner. The petitioner claims to be the owner of certain plots of land which was purchased by the Eastern Coalfields Limited upon registering a deed and on payment of valuable consideration. Stop. The petitioner seeks appointment on compassionate ground.
Not compassionate ground, my lord.
Land loser scheme.
Land scheme. Land loser scheme.
Next.
Land loser.
It has been submitted that the claim of the petitioners petitioner for appointment was processed by the authority, and police verification has also been done. Since thereafter, the matter has not proceeded further. A communication dated 5th of February 2025 addressed to the learned advocate representing the petitioner by the area land dealing officer, Salanpur area of the Eastern Coalfields Limited, intimating that the employment proposal of the petitioner is under scrutiny and process has been handed over by the learned advocate representing the petitioner. Stop. The same is taken on record. Stop. Learned advocate representing Eastern Coalfields Limited submits upon instruction that the subject land which the petitioner sold to ECL, claiming to be the owner, was scrutinized later on, and it was detected that the petitioner is not the owner of the land. Stop. The land in question belonged to other third parties.
Now we are to ECL under Nationalization Act. It has been vested with.
The land is currently vested with the Eastern Coalfields Limited under the Nationalization Act.
National Coal Nationalization.
Nationalization Act 1970s.
Coal Mines Nationalization Act.
Lord, the record of rights have been prepared under the Estate Acquisition Act and later Land Reforms Act. Now they are saying, my lord, it has been, my lord, vested.
We will produce the document, my lord.
Was it your excess land? Vested?
This was purchased, my lord. That is Estate Acquisition Act, my lord. That a bear case was there, my lord. After vesting, I was permitted to retain.
This was your retained land?
Exactly. That's why my lord, record of rights have been prepared.
Anyway, let them come. Achha. To adjudicate the issue in question, Eastern Coalfields Limited is directed to prepare and circulate a report supported by an affidavit annexing all documents in disclosing their stand by 21st May. The writ petition is made returnable on 22nd June. Stop. It will be open for the petitioner to file exception to the report, not file, prepare and circulate by 17th June. Service is taken on record.
Grateful.
Next time your junior is going to handle matters and you stay by her side. All right. Let her come prepared. All right. You stay by her side. Next. Yes.
Lordship, I am for the petitioner in item number 16, 17, 18 and 19. All are analogous, Lordship. Lordship, I am praying for not this week.
Why?
No, there is a bereavement in the family of the learned counsel, Lordship.
On the prayer made on behalf of the learned advocate for the petitioner, seeking adjournment, hearing of the writ petition stand adjourned. Stop. List on 4th May. Let notice be served upon the respondents, communicating the next date of hearing. The Passover matter, please call.
14 নম্বর 14 ছিল না 14
Did you check up the judgment of Justice Basak?
Yes, my lord. If it was sent to me on WhatsApp. It's a interim order. It's an
Has
interim
it
order.
been finally disposed of or anything of that?
The order is given to
know.
me now, my lord. I think paragraph 25 or 26. Please see, my lord. It's an interim order.
Maybe.
Is it-
But then paragraph
Uh,
23,
Lord, interim order, my lord, will not have any value of as per
no,
precedent.
but then the findings, the observation is there. The authority
Lord, kindly
decided.
come to 26, my lord. Please come to 26.
Paragraph 19 of the division bench.
Nobody is seeking any right.
Yes, my lord.
This is somebody else's order.
Correct.
It
Lord.
is only the observation that the authority decided the application for study leave, treating the petitioner as a trainee reserve. He says that he is not a trainee reserve. He wants study
Lord,
leave. It's separate.
But
Nothing more.
I follow that. As a trainee reserve, he has taken leave
years
for
leave.
3 years. He has enjoyed leave for 3 years. 3 years was over, not in 2023 September. I think 21st September 2023. Now, Lord, under the service rules, Lord, the West Bengal service rules, the maximum period during which one can take leave is ordinarily 12 and in certain cases 24. That if your lordship please comes to, my lord, page 72 of the writ petition, my lord, that has been set out. If your lordship please sees appendix 5 of the WBSR has been set out at page 72. Now, my lord, please come to the lower portion. It is further stipulated that 2, maximum amount of study leave. The maximum amount of study leave which may be granted to a government employee under the WBSR. Now he's staying under WBSR. Shall be A, ordinarily 12 months at any one time, and B, during his entire service, 24 months in all, inclusive of similar kind of leave for study or training granted under any other rule. So under any other rule, he has already exceeded the maximum amount of 24 months.
No,
As a
but
trainee reserve, he has taken leave.
trainee reserve rules is different.
Under any other rule.
Yes.
In the brackets. So he has already availed of 3 years, 36 months by virtue of applying as a trainee reserve. Now he says, I've completed the leave which I was entitled to under, as a trainee reserve. Now you give me further period of 24 months.
3 years possibly
3
this
years,
time also.
3 years. Now look, that exceeds the maximum amount permissible.
The earlier period, 3 years, which you granted leave,
Yes, my lord.
then how could the other leaves be accumulated in case of the petitioner? If
Lord-
he has already
Now, Lord,
taken 3 years of leave, how
Lord,
is the other leave still
Lord,
there?
if your lordship is pleased to come to, my lord, the chart that he has given at page 60.
Yes.
Lord, this is during his entire career as of September 25 as casual earned half pay special casual. These he says are accumulated leaves.
This was on September 2025
That's
as
right.
on,
Lord, that's right.
right?
Look, that's right, Lord.
There are still
Lord,
some leave.
Lord, he is not saying that you permit me to avail of these leaves and also allow me to take whatever may be the deficit as without pay. That is not his application. His application is in terms of the WBSR, give me study leave. Now,
But
Lord,
then
if he
he is
applies
agreeable.
under this, we will consider under this.
He is agreeable if you accumulate
Lord, that
his
is recorded.
non-used leave, those he has in his balance.
Let him apply today, Lord, we will consider by Monday. Let him apply today itself that I'm not proceeding with the leave under Lord Appendix 5, my application under Appendix 5, where it's a maximum of 24 months. I am applying to use up my accumulated leaves, and whatever is deficit, it will continue without pay.
The others you are paying, he has annexed documents to
Page
show.
95, let.
There are documents. See one Pradeep Day.
Page 94, he was allowed trainee reserve benefit. And when I kindly see after this trainee reserve completed, page 95. Shamratha, please see page 95, clause 4. He is joining on 2nd June 2025, last column.
Right.
And page 91. Then again on 24th July 2025, in the same month, But he was allowed study leave for DM course. The course I am now seeking for.
But what was the consideration? I do not know. Lord. Under what consider?
No, this is one of the examples. There are so many.
One minute. There may be separate considerations, but the rule remains the same.
Right, Lord. And the rules, Lord, if a lordship see, I have shown a lordship appendix 5 that has a maximum limit.
No.
Not only that, Lord, your lordship will find that if your lordship first there has to be satisfaction of appendix 5 that it has to have a close connection with the sphere of work. It should be in the public interest and it should not remove him from regular work. All that is there. Those satisfactions will take place, but the maximum period of study leave permissible, Lord, that is mandatory.
And that is mandatory for all.
That is mandatory for all.
Right. Now he has shown pages 91, 94 and 95.
Then Lord, we'll have to take out those and see how factually it may be different, whether it is application was under this rule or there was something else applicable.
That
Then,
means there are other rules where
I do not know, Lord. I do not know.
can
Lord.
be made applicable.
Lord, I am seeing, Lord, his case.
Yes.
Under what considerations others were allowed, Lord, I have not
No,
applied
because
myself.
the reasoned order mentions about these cases.
Now, if your lordship sees, Lord, the orders,
The order impugned.
now, Lord, the order impugned refers to all the judgments that have been relied upon by my learned
And all
friend
the orders.
and deals with them.
And they have
Your
said
lordship
this
will find
with their exception.
From page
74.
Page 74, your lordship will find
Arif
Arif Mohammed's case, Lord, I've showed your lordship is, Lord, is a prima facie view at the interim stage.
But then you've allowed. You have allowed. The court may have passed an
Court has
interim
allowed
order.
it. Lord, court has given an interim order.
And you have accepted and granted the leave.
As an interim order, your lordship will see paragraph 26 that the right is reserved. Lord, please have a look at paragraph 26 of Arif
Is
Mohammed.
it your case that you are going to withdraw this permission that you've granted?
No, Lord, I cannot take that decision today, Lord. I am briefed in this matter, but please see paragraph 26 for a moment, Lord. Only for a moment.
It is an interim order
If
without.
on final hearing of the writ petition,
Right.
found writ petitioner is not entitled to release paid for, then it will not create any equity.
True, but then the person is in the study leave and is undergoing some course.
Subject to the final result of the writ petition.
And what about Kuntal Shah?
Clarify that this interim order of ours will not create any right, title, and interest or equity in favor of the writ petitioner if on final hearing of the writ petition it is found that the writ petition is not entitled to the relief as paid for.
Well, let us forget it. Arif Mohammed for the timing, let page 75. Kuntal Shah, they have said this is exception. So all the example we are citing.
No, only one, only Kuntal Shah.
Their exception. Shoykot Shah, again.
Shoykot Chakraborty,
Again exception.
Be treated as
Again
an
exception.
and should not be treated as precedence.
And now we have collected Pradeep. They will be coming and saying that again exception. Let them do some exception for us, for me also.
Lord, so far as exception is concerned, Lord, your lordship will find Kuntal Shah and Shoykot Chakraborty.
There is another one, Dr. Shoma Mukhopadhyay. But then, according to
No, Lord, that
the
has
authority,
been distinguished on facts.
she never availed the benefit of plenary reserve. But then the period is also 3 years. More than 3 years. 25 to 28. DNB. This course is for 3 years. So everybody who's there joining the course has to take leave for 3 years.
The writ petitioner joined in 2025. It's not that writ petitioner is joining now. If your lordship is pleased to see page 45, in June 2025, he has taken admission.
He is not being able to pursue the course.
Lord, he came back in 23 and in 25 he took admission.
Yes.
Page 45.
Right. He came back in 23 from a
23
different
September from
a
pursuing his different course.
Yes.
And in 25 he's taken admission here.
Right.
I first take admission, create equity in my favor,
No
and then
equity.
apply for leave.
No equity. Had he not passed the NEET counseling, there was no scope for seeking leave.
All that has
admission,
happened, but all that
nothing.
has happened long back, Lord.
Not long back, he is pursuing. And the course that he intends to pursue for higher study.
Lord, please see page 45. He has taken admission on 19 June 25.
Yes.
With you have taken admission on 19 June 25.
Hmm.
This is Sri Aurobindo Institute.
Hmm.
Yes. Rather, page 53 is the no objection given by the authority.
Maybe, that's true, but now
Month of September 25.
Now we are in the realm of rule, whether the rule will apply to him or not. Now the question is whether he, by this method, he can take leave of 6 years. 3 years with full pay as a trainee reserve, and now another 3 years study leave in terms of the WBSR, so totaling 6 years. Without even the mandatory gap of 3 years. Now, Lord, if your Lordship, please, Lord, I should.
See, tell me one thing, petitioner, this page 45 which has been shown,
45.
June 25, right?
45.
Page 45. You are instructed to join the department on or before September 25, failing which the institute can initiate the process of cancellation of
That
your
not been done, right? We are communicating with them. Right?
communicating. Your learned senior friend says that in September you will overcome this 3-year barrier.
Right? They will not wait for this time. It is because of my communication and the litigation they are waiting.
I keep the litigation pending.
That will not help actually. But ultimately, I have to complete the course also.
Certainly, you have to complete. Otherwise,
I have to execute a bond that I'll serve again. Otherwise, I'll compensate them. I'll have to compensate them. That's the usual undertaking. It will be ultimately of their benefit.
Not their benefit, it's benefit to the public
That I have
in general.
yes, I have pleaded in my petition.
Not nobody, the department has.
Department, I mean state, who is under obligation to serve the people.
Yes, the public will be benefited.
Yes, yes.
Are you willing to forego your pay?
That I have to take instruction, but I'll be requesting your lordship that kindly interpret the rules. The rules he is citing.
Yes.
The trainee reserve rules has no application in my case, and that they have also accepted in other cases also. If I want to avail trainee reserve benefit once more, that I can do only after 3 years. That's the provision.
But
Appendix 5.
No. Trainee reserve rules. The 3 years bar is only in the trainee reserve rules, not in the WBSR. So and this is for trainee reserve benefit only. Now, if I want to avail this benefit once again, then I have to wait for 3 years. That's the provision. Has nothing to do with my WBSR. Now, WBSR has never said that I have to wait for 3 years. Rather,
WBSR says you can get maximum 12 months, and during your entire service tenure, 24 months.
And that they have calculated. Now, kindly see once the page number.
45.
24, including under other
Then calculation does. Now, kindly takes up page 70.
That he has exceeded.
70.
Rather, 81 is the entire calculation. How they have regularized in other cases also.
No. In other cases, I understand.
No,
in your case.
form of calculation. But I have earned leave with me. I have shown to losses. I have leave balance. I have not extraordinary leave with me. But in case of Kuntal Shah, they have made this calculation of 248 days and 169 days. This is how they have calculated. And I have shown to losses that how much leave balance I have. Page 60. Kindly compare with my leave balance and this order.
See, so the 3 years bar is not there in the service rule.
Yes.
It is there in the training. You also. 3 years bar is not there in the service
It is more
rule.
stringent under the WBSR.
It is?
More stringent under the WBSR.
Stringent, the period is stringent.
Sorry,
but the bar is not there.
No, bar that you have to serve for 3 years, that is not there.
Yes. So
But
if
not-
that
but-
be so, then the period of leave is troubling you.
Lord, the period of leave is troubling. Plus, if your lordship kindly sees page 72, my lord, please see, starting with page 71. If I am to please see rule 166, which has been quoted,
Service rule.
166 of the WBSR,
Yes.
Roman 10, special kind of leave includes, then last word of that line is study leave. First line,
Yes,
last word, study leave. Then come to capital B, 175 2B, Roman 3. Then kindly see Roman 3 on the next page, 72. That's the leave can be granted for 24 months, where leave is required for the purpose of prosecuting studies certified to be in the public interest, provided the government employee concerned has completed 3 years continuous service on the date of expiry of leave of the kind due and admissible under these rules, including 3 months extraordinary leave. Now, these rules, it can be argued, no, these rules are not the trainee reserve rules. But by virtue of Appendix 5, the last line of that page, it gets incorporated, which it talks of training under any other rule.
That means the tenure.
Tenure of 3 years also gets incorporated here. Because of
Yes, has completed 3 years continuous service
on the date of expiry of the leave of the kind due and admissible under these rules.
Yes. So
now he is asking for leave under these rules.
Right.
He must have had 3 years of continuous service before this application.
He is in service since 10 years last.
Now he is in service, but he has been subject to leave.
Leave.
3 years.
A different rule.
Under different rule, he has taken leave.
Yes.
Now that different rule gets incorporated by reference by virtue of Appendix 5 to P.
That means it comes the period. Here it comes the period.
Period comes in by virtue of this incorporation of 3 years maximum. 3 years you have to work continuous service after your previous leave and before applying for the next leave. That gives some amount of service back to the government.
You obtain a bond. This is what I was inquiring on the last occasion as to whether any such candidate is required to submit any undertaking, a bond that he is to come back and serve the government, because he'll be studying at government expenses. And if he does not serve the public, it becomes the whole money goes down the drain, right? So he says there is a requirement of filing a bond or something. I do not know what the figure is.
This is 15 lakhs.
50?
15 lakhs I have to refund in case of failure.
Failure to join. All right.
There are 2 bonds. I have to join. Failure, how to execute. This is one of the sample copies. The sample copy is also already there in the after the Appendix 5 at the end. Kindly simulate Form 2 and Form 3.
Which page do I get it?
Page 13. Rather. Page 118.
100 to, 100 bolcho to. Bond requirement 100 to.
Form 2 page 13. Sorry, we can get it. Take it. Come here. This is the exact sample copy. In the event of my failing to resume duty.
Resigning or retiring from service or otherwise. Quitting service without returning. The expiry or termination of the period of study. 3 years after my return to duty. Pay the on demand 15 lakh together with interest from the date of demand of the government rate.
I think Shomrat will not stand in the way of studying.
Otherwise, apply under the Public Demands Recovery Act for recovery of this money.
You have to, if this the procedure is, what can be done?
Because bond does not
means the money is being paid. That is all right.
is just like an undertaking.
Yes. But what the law is,
The
there is there.
two problems. One is the number of years of continuous service he is required to render after he has resumed, and second is the period of leave that he is now applying for.
With all due respect, my period of service is continuous. Even if I'm on leave, I'm in continuous service.
Lord, the trainee reserve is a special provision under which he is getting emoluments without having to work.
Sir, all this thing is only for 3 years and 3 years studying at government expenses. 3 years he've already taken and the next 3 years. The fight is for this. If he is willing to forego his salary without pay,
Lord,
then
as I
that's
submitted,
different.
let him apply today. We will
That is
dispose of
different, I can
by
understand.
Monday. I will
But
dispose
since
of.
you have
But your lordship's interim order records that he is willing to gives an indication that he is willing to withdraw. If your lordship please takes page 67 in the first round. First round, please see page 68, paragraph 6.
Yes.
It has been submitted by the petitioner that the petitioner may be permitted to use the earned leave, half pay leave for allowing study leave apart from the extraordinary leave that is entitled in service.
Yes, he still says.
If he wants to exhaust this and something more remains then he is not taking leave in terms of not the extant rules. He is exhausting his leaves. Then what happens if there is a deficit? Then he has to say, no, well,
there will be some deficit.
There will be, naturally.
3 years.
Because it is only 400 odd.
Yeah, right. It's only, or yes, 493
1.5 years.
Right, then the
He
balance.
has to agree to.
So, rules is study leave for 12 months and then extraordinarily. That would be added. Now, let them act in terms of the rules. What they are doing in other cases also.
The whole career.
Why I'll be treated differently?
What is your age now? How many years of service left? Oh, 36 years.
That is not the issue. I have qualified in the NEET and then I got admitted.
True. It's not that you're going to retire immediately and you will not be in a position to render service to the state. It is not that. You still have some period left.
Radiology, na? Radiology.
Cancer treatment kurbo. There's only one post.
Yes. What is to be done? Public interest in one side.
Lord, public interest, Lord, is a very vexed question. Person is really speaking, he is increasing his qualifications
for the benefit of mankind. Not for his personal benefit.
That we all say, not whether it is for the benefit of mankind or for benefit of his own self. That is a different thing.
For mankind.
He will not gain the knowledge and keep it to himself. He'll use it certainly, whether it is for government service or private practice is a different thing. But definitely it's going to serve the mankind.
And him also.
I told, if it is for private practice, it is all right. He earns, but he renders service. He renders service.
Like us.
Not that. Not that. He is just earning the knowledge, gaining knowledge, and he sits back at home. That he is not doing. He is going to serve the mankind. Now,
our experience and lordships being on that side will never get that experience. On this side, we know what we face in hospitals and nursing homes, and how it is different in Calcutta,
from the other states.
From other states.
That has to be regulated by the
Recently, I am having aged parents, and I have also some other relatives who are requiring treatment. It is
difficult.
It is.
So why don't you permit these doctors to remain in service with you? If you behave like this, they will, at the drop of a hat, they'll leave and they'll go. You lose this talent.
And the government doctors in our state is getting less benefit than other state.
Yeah, that is true.
Let my learned friend take instructions. If he is willing to work without pay, take the leave without pay, let him apply tomorrow.
After exhausting all his leave, not that leave without pay all 3 years.
No, for the
he will work without pay.
After exhaust, let him apply tomorrow. We will dispose of by Monday.
I need not. Whatever rules is there, let them apply
in terms
accordingly.
Of the, in terms of
they
the
say
rules,
in their impugned order.
In terms of the rules, 24 months we can give maximum study leave.
But my unfit cannot develop the case what is there in the reason decision. But
True.
the entire reason is like that they have treated this is an study leave, whatever I have availed on 3 years. 76 last paragraph. That should be set aside.
24 months inclusive of similar kind of leave for study or training granted under any other rule.
And it is shall be.
Right.
Ordinarily and maximum.
Yes.
When a maximum is prescribed, it's difficult to say that this is only directory and not mandatory.
Yes.
If only A had been there, then it could have been argued that this is
Ordinarily. 24 months in all.
না দাদা এখান থেকে দেখাচ্ছে পেজ 73
detail তো And this has been dealt with. It's a reasoned order. This aspect has been dealt with.
No, page 76. See the last paragraph.
76.
Last paragraph. This is the consideration. I have duly considered the case of the petitioner and hold that whereas he, after availing 3 years of paid trainee reserve for undergoing MD, has sought further leave for undergoing DM during this mandatory 3 years waiting period. This possibly is incorrect.
Kindly ignore that. Come to B.
Yes. Since he has already availed paid leave equivalent to study leave. This is also going.
Any reserve rules.
This is also going somewhere contrary. Paid leave equivalent to study leave in all interpretations for a period of 36 months. Therefore, he is not entitled to any further study leave. But trainee reserve rules permits this leave to be taken.
Lord, because trainee reserve rules permits, Lord, that is why, Lord, that carves out an exception.
Right.
The WBSR. Because that is a later rule. It's a later and it's a more specialized rule.
Yes, what do you do?
Like this clause 2, my interpretation.
Which page? Maximum.
That's maximum amount of study.
Yes.
This says that I'll be getting 12 months only study on account of study leave. That's all.
I didn't get it. Maximum amount of study leave
is 12 months.
Ordinarily. One time.
One time.
At a stretch, you can take 12 months.
But maximum amount of study leave
during
which may be granted to a government employee shall be ordinarily 12 months at one time. Then, during his entire service, 24 months, in all inclusive of similar kind of leave for study or training granted under other rules. So, this study leave of 24 months that I can avail during my entire career.
It is inclusive of similar kind of
all rules.
That means trainee reserve rules also.
I expect for the time being.
If
now
that be so.
Now let kindly see 52 rather, page 123. Oh, sorry. Now this is page.
Is it not there in your brief? What?
I have handed over the appendix that they have not quoted in their
appendix you've given. Page 123.
Page 123.
Yes.
That every government employee clause A is permanent employee who has been granted study leave or extension of such study leave shall be required to execute a bond. Clause A. Then
bond is different.
Clause 5. Then clause 5. Accounting of study leave and combination with leave of other kinds. Study leave shall not be debited against the leave account of the government employee. Study leave may be combined with other kind of leave, but in no case shall the grant of this leave in combination with leave other than extraordinary leave involve a total absence of more than 28 months from the regular duties of the government employee. Therefore, that whatever leave I am entitled to on account of study leave
plus 4 months.
plus
4 months.
this 28 months.
4 months.
This 28 months.
Total absence of 28 months. এখানে 24 এখানে আরো 4 হলে 28 হচ্ছে।
28 months on account of extra involved into a total absence of 28 months.
This leave
28 minus 12. So 28 months minus 12 months is the extraordinary leave. And that is how they have calculated at page 81 of the petition.
Study leave plus other leave is equal to 28 months maximum.
Rather, 86 is more clear. 86 is more clear. By referring this rule only.
86 in respect of Shoma Mukhopadhyay?
Yes.
Yes.
More clear in respect of these rules only. By referring appendix 5. The undersigned is directed by the order of governor to say that the governor has been pleased to allow study leave in respect of Shoma Mukhopadhyay of the West Bengal Education Service, now posted as Professor HOD Department of so-and-so, for a period of 1 year, that is 12 months, with effect from the date of release for pursuing training reserve training course, under rules 197 of the West Bengal Service Rules, Part 1, and with Appendix 5, Clause 2A, she will get further 1 year of study leave on applying the same in due course of time, and rest period of course shall be regularized as per
Extant leave rules.
Then the candidate will have to execute bond from 2, then during study leave officer will draw pay, then medical teacher permitted for study leave may be released on a concept. Again, the page I've shown at page 81, again, can you see? Page 81.
So it is not that a solitary case that the petitioner is seeking. There are other doctors also who are going for higher studies.
That's my case. That should not be treated as.
And see, on leave 120 days, page 81, 120 days. And this was mentioned to be an exception. Why exception? Why will an exception be created in respect of one doctor and another will not? 248 days under Rule 175 of WBSR.
So you got the same.
In 81, earned leave 120 days, extraordinary leave 248 days, but it doesn't talk of study leave.
Yes.
কোন জায়গাটা বলতো 81 এর?
First paragraph. Third line. No.
Absence has been regularized as study leave.
Dada, page 78. This is a continuation of page 78.
Yes, second line. Study leave in respect of Dr. Kuntal Shaha.
No, this is like a negative article 14.
But why?
No.
If it is negative, if you say that an exception has been carved out for him, then you should take back whatever is given to him.
Not an exception carved out, but this has happened. It's
and not in one single case. There are others also. Arif, you say it is an interim order. Kuntal, you say this is an exception. And there is another one also, which has been said to be an exception.
Well, it's not negative because they have interpreted this appendix 5 and given the benefit. Not that they are not referring to appendix 5. They have ignored appendix 5.
Kuntal is exception. Shoikat is exception. Shoma has got it. Then also, I don't think you will get many such doctors who would like to go in for higher studies to this level.
I'm not
You go through this once again and you come back tomorrow, think over it, what can be done, how relief can be granted, if at all. If after exhausting leaves, some amount is due, then he'll go without pay. You consult with your director also.
I
Because,
spoke with him this morning.
right,
just
because you
understand.
cannot take independent decisions. You have to rely upon whatever instruction. And see if
But I understand the
service,
plight because
his service can be used for mankind.
I understand the plight of the man that
Plight of
he's
the-
only trying to add.
No,
No.
plight of the petition, plight of the common people.
No, common people তো বলতে পারবো কি অ্যাটলিস্ট লোকটা তো চেষ্টা করছে যে আমি পড়াশোনা এডুকেশনটা বাড়াই
আমি শুনছি না পাশ থেকে যে তুই কি করে প্রশ্ন মতো করতে পারো।
So what do? I keep it tomorrow?
Keep it tomorrow. One way or the other, I'll take instructions.
Not the other. The positive way. Because your learned friend will definitely depend upon whatever way you advise your client, and the court will also look forward to it. Right? See if
My learned friend and I share a very cordial relationship. I'll try my
no, there is no reason for not being cordial to each other. There is no reason.
whatever it is, we should do it before 29th.
Please come.
হয়তো 4 তারিখে পর বলতে
Submission made on behalf of both the parties. Stop. The the report on leave indicating the leave balance of the petitioner as on 8 September 2025 has been placed before this court. Stop. It has been submitted by the respondents that if the petitioner intends to utilize all his unavailed leave and thereafter, if there is some period required for the balance 3 years study leave period, the petitioner may apply afresh for obtaining leave without pay. Stop. Paragraph. Learned advocate for the petitioner submits that in terms of the service rules and appendix 5 of WBSR-1, the petitioner would be entitled to the study leave for the period of 3 years as has been allowed in respect of similarly placed medical officers. Stop paragraph. To allow the respondents to come back with further positive instruction released tomorrow. Take back Justice Basak's order and this one which you handed over.
Since your lordships permit us to also not only argue, but there's a difference between get instructions positively and get positive instructions.
That is the reason the word was placed prior to instruction. Yes. Oh, did the yes? Why? Any reason not to come back? Then? No, I'll come back. You want me to continue? Which one? Which matter is yours? There are other matters in between.
Item number 20, Your Lordship, I am appearing for the petitioner, Your Lordship. The instant matter pertaining to Your Lordship, disproportionate punishment and pendency of a review application before the reviewing authority. The fact of the case is that
Where is the review application?
the review application has been annexed in the CAN application, Your Lordship. Please come to my CAN.
20th of November 2025, page 7.
Second, my lord. Yes, my lord. 20th November 2025.
And is there any provision for review in the
Yes, Your
disciplinary?
Lordship. Yes, yes.
There is.
There is. It is also mentioned, Your Lordship, in the subject, mercy petition under Regulation 18, prayer for substitution of penalty of removal.
From service with no bar for with a lesser penalty and reinstatement.
And has to be...
1 minute. Are you willing to consider this?
Let's say, first of all, this CAN application just now been served upon me. The principal cause of action,
Whatever it is.
the disciplinary, the
Whatever it
appellate
is.
authority's order.
That he says.
There is no scope for review, subject to correction.
Show me the service rule. It has mentioned regulation
May I?
18. Is there any provision for review?
my lord?
Please show. Show it. Give a copy to your learned friend also, because he is not aware.
Regulation of which? Bolo, ami dekhe nichi. Regulation of which?
Indian Bank Officer Employees Discipline and Appeal Regulations 1976.
Allahabad Bank employees. He was the employee of Allahabad Bank.
But at present, it has been merged. And it
It has been merged, but his entire disciplinary proceedings, let's say Allahabad Bank regulations, Allahabad
Say
Bank.
it is not applicable and reject it. Where is the difficulty?
But so we will consider his review application. Yes, yes.
Please come.
Yes, without wasting a lot of time. Yes.
The petitioner was employed with the Indian Bank, which subsequently merged with the Allahabad Bank. Is it Indian Bank merged with Allahabad?
Allahabad Bank merged with the
Allahabad banking with Indian Bank. Allahabad Bank, which subsequently merged with the Indian Bank. Stop. A disciplinary proceeding was initiated against him, and a penalty of removal from service with no bar for future recruitment was imposed on him. Stop. The order of the disciplinary authority stood affirmed by the appellate authority. Stop. The petitioner has thereafter filed an application for review of the punishment imposed upon him. Stop. He alleges that the said application for review is pending consideration. Stop. Paragraph. Learned advocate representing the bank submits that there is hardly any provision for review of the punishment imposed upon the petitioner. Stop. The order of the disciplinary authority has been affirmed by the appellate authority. Paragraph. Be that as it may, as it appears that that an application for review of the punishment imposed.
Subject to correction. Sorry for interruption, Your Lordship. I am not saying as to whether it has been received by the authorities or not. Review.
There is no proof of
no
service.
indication. No indication.
Where is the proof of service?
It has been served upon the authority or not, submitted at all or not.
1 minute. Where is the proof of service of this letter?
Maybe it has been served through mail.
Served through?
Served through mail, my lord.
Mail to apni annex kore
Be that as it may, Rage. It has been submitted that there is no proof of service of the review application upon the competent authority. ঠিক আছে? Paragraph দিয়ে. Be that as it may, as the application seeking review dated 20th November 2025 is annexed to the connecting application filed by the petitioner being Can 1 of 2026, accordingly, without entering into the merit of the same at this stage, The instant writ petition stands disposed of by directing the competent authority to consider and dispose of the petitioner's representation strictly in accordance with law at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. Learned advocate for the petitioner is directed to forward a copy of the representation dated 20th November 2025 to the aforesaid respondent at the time of communicating the order of the court. Paragraph. It is made clear that this court has not entered into the merits of the prayer of the petitioner, and all points, including the point of maintainability, is left open to be decided by the respondents at the time of consideration of the petitioner's representation. Disposed.
My lordship, says no affidavit has been called.
Since the writ petition is being disposed of without calling for any affidavits, the allegations made therein are deemed not to have been admitted by the respondents.
Lordship, oblige, lordship.
Disposed. Can disposed.
Can a writ petition also dispose of only writ petition?
All disposed.
Obliged, obliged.
What will be kept pending?
Yes, yes, lordship.
Nothing to, it is you will take a decision.
Lord, obliged, obliged, highly obliged.
Yes. Hmm.
No, my lord, I had talked with Mr. Jana. He is not appearing in this matter.
Is anybody else appearing for the Port Trust Authority? All right, let me see what it is.
This is my affidavit of service.
Hmm.
My lord, this is against the inaction on the part of the Port Trust Authority to award, my lord, the family pension to a disabled, mentally disabled son.
Son.
Okay. Now, my lord, earlier, my lord, both the sons were in job. Now, before the death of my father, who was a pension holder, elder son becomes sick, mentally sick. Now, I have also made an application under Section 14 of the People's of Right to Peoples of my lord, the Disability Act of 2016 for appointment of guardian. That is pending, and in that application, my lord, a medical board has been directed to be constituted by the Bangur MRI hospital. That is still pending. Now, under this situation, what I pray before your lordship at this present moment, kindly direct the, my lord, the Port Trust Authority to file a...
Is there any provision for grant of disability pension by the Port Trust Authority?
Yes, my lord, that is a provision.
Where is that provision?
And I tell you this. My lord, there is the act. My lord, there is the act called, my lord, these regulations may be called the Port Trust Employees Pension Regulation 1988. My lord, if your lordship kindly turn to Rule 37(5)(I), kindly excuse me, my lord, I have marked it. Kindly excuse me, I have only one copy. It provides, my lord, if the son is mentally disabled, my lord, he is entitled to have the family pension.
One among two or more children of the employee. The pension will be given. The pension will be given. Which vacancy is 24 years the contract she gets to have it not in the sun. Disability, right, children.
বোর্ডটা যে কনস্টিটিউট করেছে
Please come.
Case, one point is there.
What?
That representation is not filed properly.
Not filed. Where is the representation?
Page 26.
Page 26.
Here account officer. page
Ah.
26. Name of meeting alert, in the chairman, respondent number 2.
You are not representing the port trust, then how you can point out this defect? If you don't appear on behalf of the authority, then how you can say this?
Be the head of the department, madam. I can ask him. What you are saying?
The petitioner claims to
What
be
I have said.
Said that. Do not say me that.
Please.
I can argue or not.
Sir,
Court decide.
please do not retort. Please do not.
No, I am
Do
telling you
not. Very
I
well.
decided that.
Somebody is raising objection. The court is here to listen. Why are you
Being a senior advocate, madam, I cannot.
All right, please stop. Acha, the petitioner claims to be a disabled. No, claims to be the disabled son, disabled elder son of a deceased employee of the Shama Prasad Mukherjee Port. Formerly known as the Kolkata Port Trust. Stop. He is being represented by his younger brother. Stop. Submission is that the not submission, allegation of the petitioner is that the representation made on behalf of the petitioner by his brother.
No, on behalf of the deceased, on behalf of the disabled person, my lord. The petitioner himself, my lord, petitioner is the representative, made the representation on behalf of his elder brother.
কি বললাম? Seeking disability pension is pending consideration at the end of the authority for a considerable period of time. Stop. Prayer has been made to direct the authority to consider the prayer for grant of disability pension. Stop. None represents the port authority despite service. Stop. Affidavit of service filed in court is taken on record. Has this been served? I do not find.
Representation?
No, the writ petition. Because your affidavit of service,
yes,
it was booked in the Treasury building and the item was delivered in the Kolkata GPO.
Yes.
Where is the service upon the Port Authority?
Just give me just 1 second time, my lord. Give me just. I have annexed all the documents with my affidavit of service.
Before IN, I do not think it has been served.
A minute.
See all your postal receipts.
Yes, yes.
Kolkata GPO.
Kolkata GPO.
Where is the service upon the?
না সার্ভিসটা কোথায় বলছে? Oh, item delivered. Kindly see.
Where?
Yes,
Kolkata GPO.
left hand side.
Item delivered where? The place is Kolkata GPO.
No. My lord, item received by the Kolkata GPO, kindly see. Item
Item-
received, item invoiced Kolkata GPO.
Hmm.
Then, my lord, item delivered
Hmm.
on 10th of October 2025.
Yes.
So this is the thing, my lord. Otherwise, it would not have been written, my lord, the item delivered, because received by the Calcutta GPO is on, my lord, item dispatched Calcutta GPOs on such and such. Treasury building, from Treasury building I booked.
And it went to the Kolkata GPO.
GPO and item delivered. And item delivered, my lord, consignee number is this.
Yes, yes, that I've seen.
Yes.
কি বললাম despite সার্ভিসটা কেটে দিন তো despite service কেটে দিন stop and affidavit of service filed in court is taken on record ঠিক আছে paragraph regulation 37 within bracket 5 of the Calcutta Port Trust employees bracket pension bracket close regulations 1988 has been relied upon in support of the submission that the authority ought to pay disability pension to the son of the deceased employee. Stop. Next. In the absence of the port authority, comma, it is not possible for the court to decide the issue conclusively. Stop. Paragraph. As it appears that the representation made on behalf of the petitioner is pending consideration at the end of the port authority, comma, accordingly the instant writ petition stands disposed of by directing the competent authority of the respondent number 2 to take a decision on the prayer of the petitioner strictly in accordance with the prevailing regulations at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. The authority may consider granting a reasonable opportunity of hearing to the authorized representative of the disabled son of the deceased employee for production of medical documents in support of disablement. Stop. A reasoned order shall be passed and communicated to the petitioner. Stop. If the prayer of the petitioner is allowed, comma, the necessary consequential steps shall be taken by the authority. Writ petition stands disposed.
Obliged.
ফেরত দিয়ে দিন রেগুলেশনটা কি লাগবে না লাগলে ফেরত দিয়ে দিন বোথ
তোমার লাগবে না তো
My lord, in 22, my lord, they challenge non-granting of promotion. That, my lord, grievance has been redressed. Yes, my lord.
petitioner has been promoted.
Yes, my lord. This is the copy of the letter.
Let me submit. Lordship, this petition was for disposal of representation for promotion
That has
as
been
well
allowed.
as promotion.
Very
And
well.
that promotion with seniority. As far as instruction is concerned, there is a changing circumstances. In this factual change in faction circumstances, Lordship, I would like to withdraw this petition with
All right,
liberty
learned
to
advocate.
file afresh with fresh cause of action.
Why? What is the fresh cause of action?
Because promotion,
Seniority not maintained.
there is a, I have been not been granted promotion for 3
financial 2023, 24 and 25. After
please
filing
come.
this petition, I have been promoted in January 2026.
Learned advocate for the petitioner submits upon instruction that the writ petition was filed seeking consideration of the representation filed by the petitioner. Stop. During pendency of the writ petition, comma, the representation of the petitioner has been filed, has been considered, and a fresh order has been passed. Stop. The petitioner is aggrieved by the same. Stop. The petitioner intends to challenge the action of the authority by filing a fresh writ petition. Prayer has been made to dispose of the instant writ petition. Paragraph. Learned advocate representing the respondents submits upon instruction that the prayer of the petitioner seeking promotion has been allowed, and the petitioner has been promoted to the rank of acting commandant. Within bracket, whatever is there, please copy. In situ, with effect from 1st January 2026, subject to promotable medical category. Upon hearing the submission made on behalf of the parties, comma, as it appears that the representation filed by the petitioner has already been considered and necessary order passed, comma, accordingly there is no requirement of proceeding with the writ petition any further. Stop. The same stands disposed of. Stop.
Lordship, this is partially allowed.
It will be open for the petitioner to challenge the action of the authority in accordance with law, if so advised.
Much up. Much up.
Yes.
On behalf of the petition, this is affidavit of service. Eastern Coalfield Limited is Lordship. Other side.
Eastern Coalfields Limited. Nobody here?
May I serve and come again, Lordship? Because they have got, all of them got, Lordship.
All of them got? What is your
The petitioner is drawing less basic pay and he has made representation.
Where is that?
Last annexure, Lordship, the representation made by the learned advocate of the petition.
Please come. The petitioner is serving the Eastern Coalfields Limited. Stop. His allegation is that he is being paid less basic salary than he is entitled to receive. Stop. A legal representation filed on behalf of the petitioner is pending consideration at the end of the authority. Stop. Prayer has been made to direct the authority to consider the same. Paragraph none represents the respondents. Stop. Affidavit of service is on record. Stop. As it appears that the representation of the petitioner highlighting his grievances is pending consideration at the end of the authority, comma, accordingly no useful purpose will be served by keeping the writ petition pending. Stop. The paragraph, the writ petition stands disposed of by directing the
Respondent number 2.
Personal manager, comma, Eastern Coalfields Limited, comma, Shodhpur R. Koriali, respondent number 2 herein, to consider and dispose of the legal representation filed on behalf of the petitioner, strictly in accordance with law at the earliest, but positively within a period of 12 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to the petitioner. Stop. If the prayer of the petitioner is allowed, comma, then necessary consequential steps shall be taken by the authority. Paragraph. Learned advocate for the petitioner is directed to forward a copy of the legal representation dated 6th January 2025 to the aforesaid respondent at the time of communicating the order of the court. Disposed.
Lordship, I am for the well, this is my affidavit of service.
Punjab National Bank.
Punjab National.
Yes.
Sadhana Pramanik. My lord,
Punjab National Bank.
But here what happened, my lord, my father was an employee of the Punjab National Bank. He died. My mother was getting the family pension. Thereafter, my mother was died. I am the daughter, widow and mentally imbalanced. The daughter paid for a family pension with a appropriate application. Thereafter, send
That
a
is pending?
representation. No, my lord.
Rejected?
Technically not pending. My lord, kindly come to page 36 of my writ application.
Yes.
My lord, here
Yeah,
the consideration has not been given, no rejection, only citing the provision. They have sent this letter to the learned advocate
Guidelines for
who
PNB
made the
which has been
representation.
introduced in the case of son or daughter.
And
That is either up to the age of his demand, which are
cleverly the cited the provision. Full provision was not cited.
All right. In addition, guidelines for family pension this is reproduced before allowing the family pension for life. The compensation certificate the handicap. Yes. What does this mean?
I don't know. I find no
Absolute
meaning.
incomplete.
No meaning. This is the provision regarding the family pension of the my lord, mentally imbalanced and daughter after 25 years of age.
Not kindly.
Provision is
one week time so that I can take instruction, Lords. Because today, Lords, you have no instruction.
That I am not standing on the way, your lordship. So regulation 40 is specific. B proviso. Second proviso, my lord. It can be given up beyond the 25 years of age. I am a divorced in the year 2020. I was wholly dependent upon my mother. In 23, my mother was died. I applied for. Well, this communication has been given to my learned advocate. With neither
Section
rejected, not
40.
allowed.
Section 40 has been quoted.
But
But then where is
very
this
cleverly
4?
it has been.
Where is this 4?
4, yes. 44.
For allowing the family pension.
4 is next page, my lord.
Please come.
Before allowing family pension.
The petitioner is a widow.
Not widow, my lord, divorced. Divorced.
Oh, acha,
Divorced daughter of the employee of
the divorced,
mentally
mentally imbalanced daughter of a deceased employee of the Punjab National Bank. Stop. She claims family pension. Stop. A representation was made by her learned advocate seeking family pension. Stop. The same was replied to by the bank. আচ্ছা আগের রিপ্রেজেন্টেশনটা ডেট হচ্ছে 4th December 2024. The same was replied by the bank on 30th December 2024. Stop. The reply of the bank does not specifically indicate as to whether the prayer of the petitioner has been allowed or rejected. Stop. The communication of the bank only refers to section 40 of the Punjab National Bank Pension Regulation, 1995. Stop.
Within bracket, my lord, employees. My lord,
That has not been mentioned in page 36.
Yes, that is, but regulations is within bracket.
I have seen that.
Yes, oblige your lordship.
Learned advocate for the petitioner submits that the bank ought to have specified as to whether the prayer of the petitioner is allowed or rejected. Stop. Without proper consideration and disposal of the prayer of the petitioner, the petitioner is not in a position to proceed with her case further. Stop. Prayer has been made to direct the bank to consider the prayer for grant of family pension. Stop. Learned advocate for the petitioner relies on section 40, regulation 40 of the Punjab National Bank within bracket employees. There is an apostrophe after S. Pension regulations, 1995, wherein the provision for grant of family pension to the son or daughter of an employee suffering from mental disability has been prescribed. Stop. The reply given by the bank to the prayer made by the petitioner has only highlighted regulation 40 within bracket small b and within bracket Roman 4. Stop. It appears that regulation 40 contains several provisions dealing with the dealing with the guidelines relating to grant of family pension to divorced, mentally disabled daughter of a deceased employee of the bank. Stop. Paragraph. It appears that the bank has not considered the prayer of the petitioner in terms of regulation 40. Stop. The section, not section, the provision, part provision of regulation 40 has been merely quoted in the letter of the bank dated 30th December 2024. Paragraph. As it appears that the prayer of the petitioner is pending consideration at the end of the bank, accordingly the instant writ petition stands disposed of by directing the chief manager of the bank to consider and dispose of the prayer of the petitioner for grant of family pension, strictly in accordance with the prevailing regulations at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. It will be open for the authority to seek for documents in support of the mental health of the petitioner. Stop. A reasoned order shall be passed and communicated to the petitioner. A reasoned order shall be passed either accepting or rejecting the prayer of the petitioner, and the same shall be communicated to her. Okay, sir. Learned advocate for the petitioner is directed to forward a copy of the representation along with supporting documents to the aforesaid respondent at the time of communicating the order.
Kindly indicate one thing. If I entitle get the consequential.
If the prayer of the petitioner is accepted by the authority, then necessary consequential steps shall be taken without any further delay. Disposed.
If this deeply obliged, much obliged.
Who has refused this?
My lord, the manager, branch manager and
Circle manager and the zonal manager.
zonal manager.
Acha, the affidavit of service filed in court is taken on record. Stop. It appears that copy of the writ petition addressed to the circle manager and the zonal manager has been
Refused, marked as refused.
returned with the postal remark within single quote, no such addressee in the address, and left without instruction, respectively. Stop. Learned advocate for the petitioner is permitted to take back the copy of the writ petition. Stop. The unserved envelope shall be retained with the records. Just cut. Take the writ petition.
Lordship,
The
there is
envelope
also
will
Lordship,
remain.
insufficient address of the chief manager. Sir,
Chief manager.
respond number 4, Lordship. No address. Acha, my copy that is blank, Lordship.
Blank.
Yes, I have.
Respondent number 1,
Subsequently there.
check up whether the
Yes,
respondent number 1's address is all right because he has been given the direction to consider.
Lordship. Chief manager, yes, Lordship.
That is all right?
That is correct.
Yes, chief manager, Lordship. Because page 36,
No,
he has considered.
from the page 36, I have copied.
All right.
Page 36, he has considered.
এটাকে ফেরত দিন, রিট পিটিশন গুলো নিয়ে নেবে, এইটাও ফেরত দিয়ে দিন।
My lord, may I
রিট
get back?
পিটিশন উইল বি ইয়েস, নামটা থাকবে।
Deeply obliged. marked
All right,
as-
come this side and take it.
Yes.
May I please, your lordships, my lord? I'm for the petitioner.
Yes.
My lord, in one line, this matter pertains to overpayment or overdrawn of salary to the extent of 17.71 lakhs and odd.
17?
17 lakhs, 71,000 and odd. My lord, kindly comes to the overpayment order. My lord, that is at page number.
I see you filed the writ petition by obtaining leave in October 2025. We are in the fag end of April 2026 and no order has been passed.
No order has been passed because, my lord, the matter was duly taken up on the next day.
The learned petitioner.
Petitioner was,
No,
yes, he
there,
was
there,
absent.
there has been a bereavement in the family.
Whatever.
Yes, I was absent.
This is the urgency
No,
in
the
petition.
urgency is real, my lord.
All right, please
My
continue.
urgency, my personal urgency was something else, my lord.
Yes.
My lord, comes to the demand notice, page number 114.
114?
14 of the writ petition.
Yes.
My lord would see that there is a letter dated 22nd of May 2025 wherein it is stated that, my lord, 17,71,967 and something, my lord, that is the overdrawn salary by me. The number of months that has been overdrawn, the period has not been mentioned. My lord, comes to the page thereafter, 115.
$36 months excess payment.
Yes.
Yes.
No, not 36 months excess payment. This is the option regarding repayment. I have to pay it back in an installment. I was given a choice of 36 months, 48 months and 53 months. 53.
All right.
Because that is the last month till my retirement.
All right.
I'm still in service.
Yes.
115 is my written objection to the option regarding payment.
Yes.
Thereafter, my lord, I have annexed certain documents also stating what my hardships are, and this is the second round of litigation, my lord. The first round of litigation, my lord, the order passed is at page number 154 before Justice Aniruddha Roy.
All right. Yes.
Justice Roy was kind enough to send it back to the authority, saying that you pass a reasoned order.
Yes.
and asked me to communicate the same.
Hmm.
Page number 159 and onwards is my communication of this order, as well upon receipt of notice of hearing. This is my written version submitted before the authority on 8/9/2025. 159, Your Lordships. And page number 180 is the reasoned order. I'll start with the reasoned order, my lord.
Yes.
My lord, may I read the reasoned order? In compliance to the order of the Honorable High Court, Calcutta, a hearing to the petitioner Sri Kanchan Kumar Roy, HC is head constable, AZ is Azimganj, the place of posting, regarding the ongoing deductions from his salary as overpayment which is involved in excess payment in favor of him in 2019 has been conducted on 8/9/2025 and 10/9/2025. During hearing, the staff concerned was also counseled over the rules and guidelines issued regarding payment involved in his ex-cadre post. Point-wise counseling made during the hearing as follows. Now, my lord, before I deal with the point-wise counseling, my lord, may I apprise your lordships that his parent cadre was constable. On deputation, he was working in the executive cadre as a assistant sub-inspector in the dog squad. Now, my lord, on 8/9/2025, my lord, he stated that there was no case of any overpayment to him and sought details of how it was calculated and showed a letter regarding the same of dated 25/5/2025 received at Azimganj Post. The counseling was, my lord, counseled that the desired documents regarding calculation of recovery (overpayment) must be provided to the petitioner, and the same. Fixation sheet 1 and copy fixation bill 6 copies has been provided to him with proper acknowledgement on 9/9/2025. I have received the copy. I'll come to that. On 8/9/2025, again, my lord, he stated, that is, my lord, the petitioner, he stated that he did not take any over excess payment. The counseling was, he was counseled that the payments made are as per rules and guidelines issued and not as per the wishes of any individual. As per the guidelines of such and such reference number dated 6/5/2016 clearly speaks for appointment to the higher post on ex-cadre basis, the pay scale or grade pay of the substantive post only to be taken into accounts. Now, my lord, to calculate whether any overpayment has been made or not, they rely on a notification or
What is your submission that were you entitled to the pay that was paid to you?
I was entitled.
You
And I'll
was
indicate.
Very well. Please come.
My lord, my submission is that
Yes, yes.
the payment
The order dated 26th September 2025, passed by the Senior Divisional Security Commissioner / RPF, Eastern Railway, Howrah. Intimating the petitioner that the recovery against the excess payment made to him would continue is impugned in the instant writ petition. Paragraph. Specific submission of the petitioner is that he did not receive any excess payment stuff. The payment that was made to him was in accordance with the rules.
And my lord, my submission is that
it has been submitted.
Any payment made is accordance to the force order.
It has been submitted that the order impugned is not a reasoned order, as was directed to be passed by the Honorable Court. Vide judgment dated 27th August 2025 in the earlier writ petition filed by him being WPA 17352 of 2025. Stop paragraph. The issue in question has to be decided upon granting opportunity to the respondents to disclose their stand by way of an affidavit. Stop. Let report by way of affidavit be prepared by the respondents and served.
2 weeks time at least.
You think you'll be able to prepare the affidavit within 2 weeks?
Not be possible.
Then why make this type of submission? 21st May.
Oh.
By 21st May 2026. Exception, if any, may be prepared and circulated by the petitioner within 17th of June. Stop. Liberty to mention the matter for hearing on completion of the aforesaid time period. Stop. The prayer of the petitioner seeking interim order restraining the authority from proceeding with recovery of the excess amount
My lord, then my
cannot be
submission
accepted
may be
at this
reported.
stage.
My lord,
Stop.
my lord, may I
The
humbly submit
petition
one?
is already in service,
Acha.
and the recovery, if any, made shall abide by the result of the writ petition.
My lord, may I humbly submit one thing? The only reason why I prayed for this interim order is, my lord, my mother is a cancer patient. I need huge funds. I am receiving, which I can indicate.
Representation.
Sir, 1 second, sir. I'm sorry.
No, ঠিক আছে.
Call item 26, please.
My lord, kindly, my lord, my salary is 60, 35 they are deducting for overpayment.
You pray before them for extending this period.
My lord, they would have done this all these while, my lord. They had a lot of time to do that. I've prayed.
Yes, next.
Grateful. Huh?
Nobody is here, item 26? Oh, you are there. Yes. What is the matter about?
My lord, the petitioner was the judicial.
Who is your other side? Did you serve?
Yes, my lord, I have the affidavit of service.
Yes.
My lord, the petitioner was the judicial officer and his service tenure was till 31st/5/2023. After that, he has received all his retirement benefits except the cash leave encashment, for which he has already intimated the respondent authorities, but there was no action which was taken.
Please come. The petitioner retired on superannuation on 31st of May 2023. Stop. His allegation is that his leave encashment due has not been paid. Stop. A legal representation on behalf of the petitioner is pending consideration at the end of the respondent authority. Stop. None represents the respondents despite service. Stop. Affidavit of service filed in court is taken on record. Paragraph. As it appears that the petitioner's prayer seeking grant of leave encashment is pending consideration at the end of the authority, comma, no useful purpose will be served by keeping the writ petition pending. Stop. The writ petition stands disposed of by directing the Principal Secretary, comma, Judicial Department, comma, being the respondent number 3 herein, to take a decision on the petitioner's prayer for grant of leave encashment in accordance with law at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. A reasoned order shall be passed and communicated to the petitioner. Stop. If the prayer of the petitioner is allowed, comma, the necessary consequential steps for releasing payment shall be taken without any further delay. Stop. Learned advocate for the petitioner is directed to forward a copy of the legal representation dated 1st September 2025 along with all supporting documents to the aforesaid respondent at the time of communicating the order of the court disposed.
Grateful, ma'am.
We good. But I'm for the status form.
My lord, I'm for the petitioner. It's the affidavit of service.
There is private respondent also.
My lord, in this case, the petitioner is challenging the appointment into the police force of the private respondent, my lord. The private respondent has a criminal antecedent and is guilty of moral turpitude, as a result of which he should not be inducted into the police force. This is the crux of the prayer of the petitioner, my lord.
Where is your representation?
My lord, it's
Page
number
page 47.
47, my lord.
How is Shahbaz and the petitioner and the private respondent related?
My lord, the incident is that they live in the same locality. Now, this private respondent, they had an altercation with the petitioner, and the petitioner was beaten up by this private respondent. A case was filed against the private respondent by one de facto complainant living in the same locality, my lord. Now, this de facto complainant, my lord, he passed away in 2019. What the private respondent does, he takes out a criminal revisional application in 2021 before Honorable Justice Tirthankar Ghosh, and he makes the de facto complainant OP number 2. And he shows that he has served upon him, and he receives an order of quashment. The petitioner, upon coming to know about this incident, he challenges the same before the Honorable Apex Court, and the Apex Court sets aside the order of quashment, and the private respondent is reinstated again as an accused. He has been missing out on dates, and in this meantime, my lord, he gets a job in the WBCS executive deputy SP he is now. And
All
using
right.
his position, he is threatening them.
All right.
And
Please come. Are you ready with instruction?
I'm not ready with instruction. The instruction has given by the inspector in charge is not sufficient, my lord. The direction, my lord, the respondent number 1 and 2. My lord, they are paid for, my lord, for their termination.
or suspension, my
And,
lord.
termination or suspension, whatever that respondent 1 and 2 may pass that order, my lord. And my lord, without affidavit, my lord, I am not. Affidavit is required, my lord.
All right.
And my lord, there was earlier this file, my lord, public interest litigation. There was a liberty given.
Alleges that the
And my lord, interim order.
representation filed by the petitioner challenging appointment of the private respondent in government service during pendency of the criminal case has not been considered by the authority. Stop. None represents the private respondent. Stop. Learned advocate representing the state respondents is not ready with instruction. Stop. In view of such submission, hearing of the writ petition stands adjourned till 18th May 2026. Stop. Learned advocate representing the state shall obtain positive instruction from the competent authority of the police department, from the home department, regarding engagement of the private respondent in view of pendency of a criminal proceeding against him. ঠিক আছে? Let notice be served upon the respondent number 7, communicating the order of the court. Service is taken on record.
18th May. Grateful, your lordship.
18.
Time for the petition author. This is a case for denying the full pension, lordship. The affidavit service, lordship.
Calcutta State Transport Corporation?
For the state.
Only state?
State.
CSTC?
I serve, lordship.
What is your prayer?
Lordship, non-considering the pension, full pension of petitioner. On the
Full
period,
pension means how much?
the petitioner getting pension, lordship. 13,231. Last basic pay was 29,900. Full pension is 50% of the last basic pay. Not considering the training period as qualifying service of the petitioner. Petitioner completed 20-year service.
And the petitioner is a retired employee of the Calcutta State Transport Corporation. Stop. He claims that he was engaged as conductor cum helper under CSTC on 16th January 2004 on contract basis, and he retired on attaining his age of superannuation on 31st January 2025. Stop. He alleges that he is not being paid full pension. Stop. A legal representation on behalf of the petitioner is pending consideration at the end of the respondent authority. Stop. None represents the Calcutta State Transport Corporation. Stop. In the absence of the authority, comma, it will not be possible for the court to decide the issue conclusively. Stop. In view of the above, the instant writ petition stands disposed of. Directing the respondent number 4 the Chief Accounts Officer cum Financial Advisor of the Calcutta State Transport Corporation to take a decision on the petitioner's legal representation strictly in accordance with law at the earliest, and dispose of the same by passing a reasoned order within a period of 12 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to the petitioner. Stop. If the prayer of the petitioner is allowed, comma, the necessary consequential steps for releasing the due amount shall be taken without any further delay. Stop. A copy of the legal representation dated 13th August 2025 shall be forwarded to the respondent number 4 at the time of communicating the order of the court. Stop. It is made clear that this court has not entered into the merits of the representation of the petitioner, and all points are left open to be decided by the aforesaid respondent at the time of consideration of the representation. Paragraph. Leave is granted to the advocate on record of the petitioner to amend the description of the respondent number 4 in the cause title of the writ petition. Respondent number 4 has been incorrectly impleaded. You have mentioned the Chief Accounts Officer, but the organization name is not here. Please mention CSTC, otherwise it will be defective. Followed? Service is taken on record.
May I pay for indulgence, Your Lordship? My learned sister, my lord, told me that if Your Lordship direct the, my lord, Home Department to consider their representation, it will.
Consideration of representation.
That he requested me, and I make the prayer before Lordship, my lord.
It is petitioner's prayer the respondent is making.
Well, she told me that.
No, she made submission before the court. She has already placed.
I ought not to have been makes a submission.
Then please do not make. All right, because it is a petitioner's case.
I ought not.
Petitioner,
I ought
please
not to have submitted.
Please do not. All right. Yes. 29.
My lord, extremely sorry, my lord, kindly.
29, my lord, I am for the petitioner, my lord. My lord, similar matter, my lord, like my lord, the other matters, Lordship has already dealt with, my lord. Life insurance officer, life insurance corporation, my lord. The petitioner is a development officer, my lord. There is already an order.
Matter pending before the Supreme Court.
Tomorrow is the date, my lord. Tomorrow is the date.
I'm not aware of.
All right. Whatever he's saying. An order was passed on the last.
Order, my lord, was passed by your ladyship, my lord.
Last week.
Delisting the other matters.
Delisting,
my lord, the other matters.
Please come. Learned advocate representing the petitioner
29 to 31, my lord.
submits that the issue in question that the issue involved in the instant writ petition is pending consideration before the Honorable Supreme Court. Stop. Prayer has been made to delist the matter for the time being. Stop. In view of such submission, comma, the writ petition stands delisted. Stop. Liberty to mention the matter after order is passed by the Honorable Supreme Court. 30, 31 and 32.
No, my lord, 29, 30,
24,
31
29
and
it
my lord,
was.
34.
31 and 34.
4 my lord is yes.
34.
34 my lord is against union. Yes, my lord, 34. 34. 29, 30, 31 my lord and 34.
29. Give your appearances. 29, 30, 31, 34. ঠিক আছে?
Grateful.
My lord, I am for the petitioner, my lord. Pray for not to, my lord.
Why?
My lord, my senior went to North Bengal for her election, my lord.
Earlier occasion also took time.
Then repeated adjournments, why will the court allow?
My lord, my learned seniors went to North
Exactly, North
Bengal.
Bengal.
North Bengal for her assembly election, and he is not unable to.
Bengal হয়ে গেছে তো election code.
My lord, some unavailable bus or train ticket, that way he not come.
What is the matter about?
Matter relating to higher scale of pay. But the prior permission is not there, and my learned petitioner is relying upon a notification circular dated 19th of May 2024 in all cases, but subsequently it has been cancelled on 14th, 8th of July 2014. 19th of May notification is relied upon.
Please come. Accommodation has been repeated accommodations have been sought for on behalf of the learned advocate representing the petitioner. Stop. In view of such submission, list the matter for further consideration on 8th June 2026.
Match up.
8th June.
Yes.
Obliged to lordship.
I'm appearing for the petitioner, lordship.
Yes.
This is my affidavit of service.
Union of India. Yes.
Well, this application has been filed by my lord, lots of a batch of doctors, trainee doctors who are my lord rendering services at B.R. Singh Railway Hospital. And my lord, their main grievance is that there is a subsisting order passed by a coordinate bench of this honorable court, where it was held that the trainee doctors pay, my lord, firstly it was held that the payment that they get is going to be equivalent to that of a salary of a regular doctor in view of the services and the long hours of services that they are rendering in the hospital. And secondly, my lord, previously they were getting pay under the 6th pay commission. Upon the 7th pay commission being promulgated, the payment shall also be revised according to the 7th pay commission.
But then how will the writ petition be maintainable? Will it not be before the Central Administrative Tribunal? Because
No, my lord, there is an order of this honorable court, my lord. I'm relying on that order, a judgment passed by a coordinate bench, which says that this payment has to be revised and it has to be made.
Payment, everything, but how is the writ petition maintainable?
In view of the observations, my lord, it is a binding order of a coordinate bench that they are not following.
Show me that the writ is maintainable. I'll see the binding nature of the order. Where is the order?
My lord, it starts at page 123. Now, the grievance in this writ petition was at page 123, lordship, annexure P2. Lord, here what happened was, Lord, they were receiving.
Whatever, was this issue raised?
Yes, my lord, it is already decided. If lordship comes to page 132, paragraph 36. Since this court has already held that the distinction made in the
You
accused
are
circular-
seeking payment in terms of the Central Pay Commission. You are a regular employee of the railways. How will the writ petition be taken up by the court?
payments have already been made.
Maybe.
It is the arrears that they are not being paid.
How does that matter? There may be several other illegalities, but you first satisfy how the writ petition is maintainable. If you want to come prepared,
My lord,
I'll
I will come back tomorrow. in
Please
that
do.
case, lordship. Okay.
Please come.
My lord, can it be kept next week, lordship?
Yes.
Grateful, madam.
When?
Lord, next Monday.
All right.
Not Monday, Monday is a maximum.
Oh,
No, I'll
Tuesday.
keep it on Monday because the combined list will be published. So I'll keep it on Monday only. The petitioners claim to be trainee doctors of the B.R. Singh Railway Hospital, Shialda, under the management and control of Eastern Railway. Stop. They challenge the quantum of pay that they are receiving. Stop paragraph. Reliance has been placed on the judgment passed by a coordinate bench of this court on 27th of September 2022 in the earlier round of writ petition filed by the petitioners.
No, they are not.
No, my lord, separate,
not
separate doctors.
Acha, ठीक है. Passed by the court in WPA number 5284 of 2022. Within bracket, Dr. Obro Ghosh and others versus Union of India and others. Stop. It has been submitted that as the issue has already been decided by the court, comma, similar order may be passed.
My lord, yes, my payment of arrears because they are already receiving payment just for a certain period. The
Similar
arrears
order
will be
na
passed.
tahabe, direction for payment of arrears may be passed. Paragraph. On the query of the court as regards to the maintainability of the writ petition before this court by employees of the railways, comma, learned advocate representing the petitioners seeks time to come prepared. Stop. On such prayer, released on 4th May. Service is taken on record. You also please come prepared as to how the earlier writ petition was entertained by the court and any order passed by a court without jurisdiction, the fate of it. All right?
Yes. Grateful, lordship. I will look into it.
Next.
I am for the petitioner. Today, your lordship would be surprised to know something.
Again, surprise.
Yes, a surprising way.
All day I only get surprises.
I think it would be the latest one and unique one also. Please kindly come to page 76.
Yes.
Show a chart to your lordship.
Are all the respondents here?
No.
Official trustee of the West Bengal?
Everyone.
Will you be representing the official trustee?
No. Wait. Union of India is also Union of India is.
Union is a
Answering responsible is Union of
Union of
India.
You served?
Yes, my lord.
18 petitioners. All right, let me see page 76. A surprise. They are working.
I have prepared it. This is a portion of my representation.
Hmm.
This is the chart. This is my lord Khoshbagh Cemetery. Your lordship is well aware about this Murshidabad, Lalbagh. Now the Khoshbagh Cemetery, for this there are total 11 posts. First is my lord superintendent. The monthly salary is 22.
22?
Yes. Yes.
There are no zeros?
No zeros. That's why I said that would be a surprise. Now next post is Kari. Total 5. They are getting 7 per month. 07.
This was fixed under the British rule, lordship.
Yes.
Thereafter, no.
And is it continuing?
Yes.
22 rupees, 7 rupees per month?
5 rupees.
You expect these people to deliver service?
Now, there was one inquiry conducted by the state authority. Now, from the
Voluntary
district to
registration.
state to central, there was to some extent recommendation by the state government. Now, central government said, we can't do anything. That is page 69.
Yes. It was decided in 2012.
2012,
Page 69.
page 69.
Yes. 2012 enhancement of
Only by
remuneration.
this 5 line, they have
Uh-huh.
settled the issue.
It's a political pension.
Political?
Pension. Political pension, not salary.
No, are they employees or what?
Yes.
Then where
Being
from
appointed
the
Then
question?
how will get the
fund, the payment is being made from that fund.
No increase in the political pension remuneration granted during the British rule will be made.
A rule of
Show me your appointment letter, please.
page 27. Madam. Appointment letter was issued by the district magistrate. Next one, page 28.
You are hereby appointed as superintendent in place of your father, as he prayed for relinquishing. Is it hereditary?
Nobody is there except these persons, Malar, who are running this, because some sentiment is also there. The Khoshbagh, Lalbagh, there are 4 Mala, the Motijhil. Those are being looked after by these people.
There are some guidelines which is appearing at page 48, Lordship.
Is it a full-time job or what?
Yes, full-time job, Mala.
You do not do anything else?
No.
No other? How do you survive with 22 rupees?
My lord, to be very frank,
7 rupees.
the persons who are visiting there,
Huh?
the visitors provide something.
It's a cemetery.
Yes.
Do not
Yes, every day there are visitors. Every
people
day there
come
are
over
visitors.
there to pay the last respect
Yes.
or something.
When I have gone there,
All right.
so these are the situation. But let there be
And anybody who goes there pays something.
yes.
But that
5 rupees, 10 rupees, or sometime, my lord, what they do?
5 rupees, 10 rupees.
Yes. And my lord, certain books are there.
Mm-hmm.
This is the books. If you may take, you may not take.
What book?
Regarding history of this cemetery and other things.
All right. That also costs only 5 or 10 rupees.
15 rupees maximum.
Or maximum 15 rupees. Yes. And the printing book also costs money. It's not that.
This is the situation. Let a report be called for. The person should not be left in this fashion.
Some Lordship in there in Murshidabad, some family members of the Nawabs also getting still date 12 rupees, 13 rupees, 15 rupees.
They are the Nawabs. They do not require money. They have got so much of
They are
wealth with
taking
them.
those money still date, Your Lordship.
No, that is
Without any
Yes, ma'am, there are Chota Nawab is still there, but who is traveling by way of a bicycle. Nothing else he has.
go inside that Nawab's place and you see the beauty inside, right? So it cannot be compensated with money. Thing is different, but the remuneration 7 rupees monthly. It's really shocking, a surprise.
Call for a report from all the authorities. Then they have to decide this issue because this should not be continued.
I think Under Secretary Judicial Department, Government of India is the appropriate authority to give answer, Your Lordship.
The Union of India is not represented. Acha, please come. The petitioners claim to be serving various cemeteries in the district of Murshidabad. Stop. It has been pointed out that the post in which they are functioning carries monthly salary of
The lowest is 5 and the highest
monthly
is 50.
salary starting from rupees 5 till rupees 22.
50. The third one,
50?
Motijhil Mosque, the third
Oh,
part,
at 50.
The other 50.
50. Stop. They pray for enhancement of the monthly salary received by them. How do you get this? Does it come to your bank account?
Yes. Yes.
By the Union of India?
Yes, my lord. Your lordship, kindly come to page 76, the last paragraph.
76.
The fund from which our salary comes was created some 2 centuries back out of Nijamat fund of Nawab Najim, Bengal, Bihar and Odisha. And it is still lying with the Government of India, classified Ministry of Home Affairs, North Block, New Delhi.
At page 48, Lordship, clause 6 says the concerned PPO has been found in the Treasury record room and it is noticed that the amount was debitable to central government under head 54 territorial pension and that the amount was reviewed by the Accountant General, Bengal.
আচ্ছা কি বললাম enhancement of will it be salary, will it be remuneration, what should be the term used? Where is salary / remuneration লিখুন তো ঠিক আছে
Can I kindly come to page 70, my lord? There is an answer to some to our RTI. Here, the term they have used.
Salaries.
Yes. Given by the block development officer.
But the central government used the word political pension remuneration.
That is the regulation, but then I don't know. Salary লিখুন ঠিক আছে none represents the Union of India. Stop. Let further notice be issued. Released on 4th May.
4th May instead 5.
Lordship, in place of 4th May, Lordship, 5th May, Lordship.
4th. Monthly list will be published. Service is taken on record. You serve upon 11 Stand Road and see who appears.
Great one.
Please.
And for the state.
For item number 33, I am for the petitioner. For this question. Service. The matters relates that I'm not getting the pension from the year 2025, Lordship. My husband was working under food department. Now, Lordship, my husband was superannuated in the year 20th February 2001 and he died on January 2023. Lordship, after that, I made a representations before the concerned department on 20th December 2024. My representation is at page number 22, Lordship. After that, Lordship, the hearing was conducted by the concerned authority and the hearing is given under page number 25. And the reasoned order was passed by the concerned authority and it was given page number 27.
What is the document in support of your marriage?
Lordship, in support of the marriage, Lordship, since the marriage was happened in the year 1981, so registrations, petitioners couldn't go for the registration. For that reason, he applied before the concerned panchayat. They have given the certificate.
When?
Lordship, it is page number. That is given in the page number 20, 21, as well as, Lordship, in my Aadhaar ration, I have also annexed.
21
Lordship.
Is dated 24. That means after the death of your husband,
Lordship.
right? You say the marriage took place in 81,
1981, Lordship.
right? The person was alive till 2021. He was in service.
2023, Lordship.
23 expired. He was in service till 2021. He never chose to
2001.
put in your 2001.
One.
Acha. He never chose to put in your name as his heir. He has mentioned his nephew to be his survivor and whatever he'll get. So in the absence of any contemporaneous document in support of your marriage, I do not think that the order requires any interference.
Now, the Lordship, what happened when during the time of my marriage, I went through different kind of harassment because my husband didn't take care of me, and he was very dominating, Lordship. That's why I could.
Husbands are always dominating. There's nothing new.
And moreover, Lordship,
will that mean that the name of the wife will not be there in the records?
Lordship, I can understand, but Lordship, the thing is, there is some kind of stigmas also there because since the main reason, Lordship, which I couldn't take it in my environment, that is, I think I'm issueless, and for that reason, there is also a ground, which that's why I was harassed. That's why I should not be say harassed. I should not be taken care of my husband prolonged.
All right. So the relationship between the two of you was not proper.
Not proper, Lordship.
Now the pension is to flow from your husband. Your husband didn't recognize you. The authority doesn't know it. Whether you were issueless, whether your relationship was not proper, the authority didn't have any occasion, right? They only see there is no supporting proof.
Lordship.
What is to be done?
But Lordship, I have annexed my ration card in my voter card also, Lordship.
Your husband was there in the rationing department. He never put his name in the ration card. Then?
Lordship, and the last documents, what I have annexed, that is the affidavit which I made from first class affidavit before the judicial magistrate first class Bardhaman, where the name of my husband was given as my, and the date was after 2001.
Please come. The petitioner claims to be the widow of one Vishnu Gopal Mukherjee, who was employed in the Department of Food and Supplies, Government of West Bengal. Stop. The employee retired from service in the year 2001 and expired in January 2023. Stop. The petitioner claims family pension. Stop. The prayer of the petitioner was considered by the authority, and a reasoned order has been passed on 17th June 2025, rejecting her claim for family pension. Stop. The same is impugned in the instant writ petition. Stop. Learned advocate for the petitioner submits that the petitioner has obtained certificate from the Panchayat authority disclosing that the employee was her husband. Stop. Where is the ration card?
Page number 31.
The petitioner has annexed a photocopy of the ration card issued in her favor, disclosing the name of her husband. Stop. She also executed an affidavit, affirmed an affidavit before the Judicial Magistrate First Class Bardhaman, disclosing that she is the widow of the employee. Stop. The affidavit further discloses that the marriage between the petitioner and the employee took place in April 1981 as per Hindu rites and customs. Stop. Prayer has been made to direct the authority to reconsider her prayer for grant of family pension. Paragraph. On a perusal of the impugned order, it appears that an opportunity of hearing was provided to the petitioner for production of document in support of her marriage. Stop. The petitioner failed to produce any marriage registration certificate or any other supporting document in support of her marriage with the employee. Stop. The service record of the employee did not mention the name of the petitioner as his wife. Stop. The death certificate of the employee does not mention the name of the widow. Stop. The affidavit affirmed by the petitioner, comma, the ration certificate, the ration card of the petitioner and the Gram Panchayat certificate relied upon by her in support of her marriage are all generated after the death of the employee. Stop. The petitioner has not been able to produce a single scrap of paper in support of her marriage during the lifetime of her, not generated during the lifetime of the deceased employee. Stop. Paragraph. The petitioner has annexed the pension payment order issued to the employee in the year 2001. Stop. The same clearly mentions that no family pension is to be paid, has been claimed. Stop. The employee was alive for a considerable period from 2001 till his death in January 2023, but he did not include the name of the petitioner as his spouse. Stop. Paragraph. In the absence of any contemporaneous document in support of the marriage, comma, the authority rightly rejected the claim of the petitioner seeking family pension. Stop. The court is not inclined to interfere with the impugned order. The writ petition fails and is hereby dismissed. Service is taken on record.
I bring for the petitioner.
I'm for respondent board, your lordship.
Well, here the petitioner had joined, my lord, the West Bengal board in the year 1996 as a Group C clerk, and my lord, he continued his service thereafter till 2019, when my lord, he was suspended. Lordship kindly sees the suspension at page 14. He was suspended, my lord, from and on, my lord, 5th December 2019. Well, the suspension continued. Thereafter, he made representation before the board, my lord, on 27 March 2023, asking for withdrawal of the suspension. My lord, his suspension withdrawal was considered by the board, and my lord, a decision was taken at page 18. Lordship kindly takes page 18.
Yes.
page 18, my lord, with reference to the above, the undersigned is directed to inform you that the matter of your prayer for withdrawal of the suspension was discussed and deliberated upon in the 22nd meeting of the ad hoc committee West Bengal Board of Secondary Education held on 17 May 2023. The members of the committee resolved that Commissioner Bidhannagar Police
It has not
Commissioner,
been allowed.
it has not been allowed, and it would be requested to expedite the investigation of Sheikh Abdul Munir, and they receiving this report of the investigation, the police appropriate steps would be initiated. Now, my lord, the suspension is still continuing. Now, my lord, I have retired, my lord, on the attaining the age of superannuation, my lord, on 29th February 2024. Now, my lord, the criminal case is still pending. My lord, this is the situation. I have not yet received my pension and other benefits also. So, my lord, in this situation, my lord, I have approached your lordship's court. But
What does the law provide?
the law provide, but I do not know, my learned senior friend will apprise your lordship on that, whether the West Bengal Services DCRB rules 1971 is the applicable rule or not. That she will say.
DCRB is
Then, my lord, if this is so, then my lord, the rule 14 says, lordship kindly sees rule 14 at the top.
Yes.
Yes, this says, my lord, a government servant who retires from the service but against whom criminal proceeding involving moral turpitude are pending in the court of law shall not be sanctioned any pension until the termination of the criminal proceedings. An interim allowance not exceeding 2/3 of the pension that granted during the pendency of such proceedings in cases of hardship. If he is convicted, and that is separate, my lord. So, my lord, on 2/3 may be released.
He, my lord, I think my learned friend is not informed properly, my lord. He is receiving this allowance. Yes, two-third allowance. Moreover, that, my lord, his provident fund has been released. And, my lord, he
Then, my lord, later file a report so that
savings
a small report will
linked insurance
what I am receiving.
that has also been released. My lord,
Your client has not given you proper
My
instruction.
lord, that I do not know. I do not have instruction.
What does it say? The board is saying that you are receiving 2/3.
No, if she says, then that is all right.
And everything has
But
been
if
paid.
this is done in accordance with rule 14, my lord, then I have nothing to say. Only thing, if she could file a report.
Petition filed. If you have nothing to say,
No, if she says that these are being given, then that's all right. She could file a report, my lord, a short report on that, subject to my lord's consideration, my lord. Only let us come back next week. My lord, for short report.
used to work as a cashier of board. And
26 lakh
defalcation
of
of
rupees.
No,
26 lakh.
that is the allegation. My lord, the criminal case is still pending.
Yeah.
The criminal case is still pending.
Criminal cases, when are they disposed of? Have you ever seen criminal
But this is
matters
the difficulty.
regarding such amount of defalcation being
working as a cashier
disposed of?
of board, 34 lakhs defalcation.
Well, that what has happened.
You
that
have enough money with
no,
you.
no, not that much.
You
Lordship will not.
require.
No, not that. Not that.
Permissible under law, my lord, we have already paid. And paying this allowance.
Okay, please come. The petitioner is a superannuated employee of the West Bengal Board of Secondary Education. Step. He superannuated on attaining his normal age on 29th of February 2024. Stop. While in service, comma, a disciplinary proceeding was initiated against him.
No, disciplinary proceeding was not.
While in service, he was put under suspension. On the allegation of misappropriation of government fund. Stop. A criminal proceeding is pending against him. Stop. He alleges that he is not getting his terminal dues in accordance with the West Bengal Services (bracket open) Death cum retirement benefit (bracket close) rules 1971. Stop. Prayer has been made to direct the authority to release his admissible dues in accordance with the rules. Learned advocate, paragraph D. Representing the board submits upon instruction that all dues of the petitioner in accordance with the rules have been paid. Stop. The petitioner is receiving the 2/3 of the pension. Stop. He has also received the provident fund dues and what else?
Group savings linked insurance.
And the insurance claim.
Group insurance
claim. ঠিক আছে? আচ্ছা. Letter report by the board disclosing the payment made to the petitioner. be prepared and circulated by, how soon can you do it?
Well, at 4 weeks, because my lord, he is receiving everything.
Why 4 weeks? Finish it
Three-
off
3
so
weeks.
that it can be done prior to the vacation, because he is receiving everything.
2 weeks.
Nothing is to be decided.
2 weeks, your lordship.
12th of May. Released on 18th of May.
Grateful, ma'am. Deeply obliged.
আচ্ছা 12th টা বাড়িয়ে দিন 15th করে দিন 15th of May and 18th of May.
18th of May to appear.
Yes, yes.
15th of May to file the report. Grateful, ma'am. Deeply obliged.
$38, is anybody there?
Yes.
You are there? Yes.
May I seek indulgence? Can it be taken up tomorrow? I have some doubt. I need to see it with my client.
All right, not today. Are you ready with instruction? All right.
I don't know, 39.
39 was your matter, or 38? Hillol is 39 and he responded in 38. I was wondering.
He said 30 or 39?
Hillol is 39. Other one, the advocate in record is different. I was.
State is Mohammad Saidullah Khan.
Not dismissed. Give your appearance. 38 is dismissed. 39, is anybody there for the union? Nobody is there. None represents the union. Released on 4th May. Stop. Let notice be served upon the learned advocate representing the Union of India. Are you aware of his name? Saurav Sengupta. Next, 40.
I don't know, my lord, I for the petitioner. I am paying for a note to develop.
Why?
I am led by Mr. Shoposhati Chatterjee. He is engaged in election, my lord.
You are here. Let him be there with the election. Why don't you proceed? Last occasion also you took time, I see. Why are you not prepared?
Only not today, then, my lord.
What is the matter about?
My lord, it's a case demobilization of the petition.
Oh, demobilization.
That my
All
lord,
right. Let him come.
My lord, 42, 44, my
Wait. This is only 40. I am keeping it on the 4th. Accommodation has been sought for on behalf of the learned advocate representing the petitioner. List on 4th.
my lord, may I be kindly allowed to file the report, my lord?
Yes. Report by the respondents filed in court today be written with the record. Who filed the report? Please check and put in the date.
I'm getting it.
Yes. 41 also same.
My lord, 41, I'm for the state, my lord.
Demobilization of civic police volunteer.
My lord, may I hand up the instruction, my lord?
Please give.
My lord.
All right. 4th.
Let it be taken on record, my lord.
Yes. 42. None for the state. List on 4th. Accommodation sought for, please record that. Let notice be served upon the non-appearing respondent. Same order. Notice be served. 4th. 44. Yes.
May I please, Your Lordship, I am for the petitioner. In this matter, last occasion, Your Lordship directed the respondent authority to file a report. They have not yet filed any report. I have not yet received any report, rather. My lord,
Mr. Ranjan Kumar Sinha and Shaunak Ghosh.
yes.
Where are they?
Twice.
Yes, I can see time to file the affidavit. What is the requirement of a report?
Report is required because, my lord, Your Lordships, kindly come to page, straightway kindly come to page 20 of my writ application.
Okay.
This is the DME rejection order passed by the Detailed Medical Examination Board. Here indicates the varicose vein right leg. I preferred review. In review, they have, my lord, kindly come to page 21. The review, they examine and suggested for USG colored Doppler for the required. My lord, interestingly, it was 24th November 25. My lord, next page 22. In the column, they have written 24. Here, the huge anomalies they have done. My lord, that is
I didn't follow. 21 is 24th of November 25.
25.
Huh?
Then 22, page 22. Again, I asked for to appear on the medical.
Huh?
This is 26th. Kindly have a look the bottom portion, the signature.
26, yes.
26. Interestingly, they have marked at 24th November. Very good, my lord. In this, my lord, I have done the USG. I have not. They have taken me at Thizim Domdom for my USG colored Doppler. Next page is the USG report. The USG studies normal. Thereafter, my lord, these documents itself shows that they have manufactured this document. My lord, and thus page 31 of my writ application, kind of look, they have prepared me in the specialist opinion on the colored Doppler for my varicose vein. My lord, after the surgical, my lord, this is the specialist doctor of surgeon. He has found that I have no varicose vein. My lord, what happened interestingly, kindly come to page 32.
With page 31, where is the mentioning that no
Yes,
varicose-
last paragraph.
Yes.
My lord,
Very difficult.
here, my lord, in clinical notes also indicates that I have no varicose vein.
Where
My
is
lord,
it?
it is non-spectral, no swelling in the existing, no vein prominence, bilateral lower limb court operation study. Normal colored Doppler study says normal. He opined. Then, my lord, finally there is no. My lord, here also indicates that there is no need to interfere of surgical instrument. My lord, interestingly, page 32, kindly come to page 22.
Yes.
The ground assigned, my lord, kindly have a look.
Hmm.
In a different ground.
In a
different ground, extension of deformity presence in left elbow joint. The reference was there, my left leg. They have rejected me my hand. This thing has happened. Very serious allegation is there. In this same the same recruitment process, kindly come to page 33 of my writ application. Next page.
I am making it only not today. You
Yes.
please call either of the two or both of them. Let them be here tomorrow. All right, only not today. Next. Yes.
My lord. December 2025, wherein that similar line of orders were passed. Last day we argued, wherein the ordinate bench was of the view that since the matter is pending for Honorable Supreme Court, this relates to that development officer LIG. My lord, my prayer, my lord, Mr. Ujjwal Rai is appearing on behalf of the petition, my lord. He is ill, my lord. He could not come, my lord. Spraying for not this week only, my lord.
All right. Yes.
Indicate the fact I am not pressing for anything today. So a similar line of interim order was granted, which says that
It doesn't matter. Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stuff released on 4th May.
Okay. Maybe on 5th May.
No, sorry. Yes.
The Supreme Court matter is coming up tomorrow.
Yes, let it come. Oh, to 4th is next week.
Well, maybe on 5th because we don't know how the situation would be in case because we want to do this.
No, because the combined list will be published on the 4th and not on the 5th. Yes.
Lordship, I am appearing for the Union of India, Lordship.
But I'm for the petition this matter.
Yes.
But in this matter, my lord, I have served copy upon all the respondents, but one vital point has been missed, my lord. That's why I have made a supplementary affidavit for the just and proper adjudication, my lord. My lord, the petitioner was transferred. Petitioner was transferred on the ground that there was a surplus of staff. That's why they have been transferred in another area where the transferring authority has got no jurisdiction. Subsequently, it transpired, my lord, that
after passing the order of transfer, they are now taking steps for outsourcing some staffs for running the said office, showing that the deficiency of staff. But I have been transferred on the ground that I am surplus. So that is a very vital point before Lordship, my Lord. So I have made a supplementary affidavit for kind perusal so that it will be adjudicated in a proper manner. When may I?
Show me your page 34 is your movement order. Madam, you are ready with instruction?
Lordship, actually, my senior is not able to come today, Lordship.
You are there. You are representing the union.
Yes, Lordship.
Then, where is your brief?
Lordship, actually, my senior is engaged in another matter in another court, Lordship.
Doesn't matter. Where is the brief? The brief should have been here.
Yes, yes, Lordship.
Because the matter is of this court.
Yes, yes, Lordship. Yes.
Then where is the brief?
Pardon me, Lordship.
Yes. Your movement order is page 34.
Lordship.
What is the date of, where is your order of transfer?
Order of transfer, my Lord.
Page 33, posting order, industrial personnel. Debraj Bhagat.
Lordship.
Where is your order of transfer?
That is on the page 33 is the order, my Lord.
Yes. You have been directed to move from Kolaikunda to Navagram.
Lordship.
Then? What?
Then, my Lord, kindly see, my Lord, thereafter I made representation. I made representation to the effect that the impugned order of transfer is, my Lord, 1st September 2025, and it's a P2, page 32.
Page?
Page 32.
Yes.
Thereafter, my Lord, I was asked to make representation. 1st September 2025 is the order, and I made representation. My representation has never been considered on the ground that they are not in a position to make any order. We have to make representation afresh. Accordingly, I made a representation, and it is a voluntary duty, my Lord, but they have not considered. And kindly see that the supplementary affidavit, if your Lordship, please to allow me the copy of the supplementary affidavit, then kindly see I have, and it's the entire document, my Lord. May I place the matter before Lordship?
32 is the requirement of raising up a new place at Navagram.
Lordship.
You were directed to join there. Then
Lordship.
what happened?
But then I was asked to make representation. If I am aggrieved
Where
by
is
any order of transfer,
Where
I have
is
made
it?
representation.
Where is the
Representation copy, my last.
where is the direction that you have to make representation?
That is the guideline. If anybody is aggrieved, it is a service guideline that if anybody is aggrieved by the order of transfer, then they can he can make a representation. Accordingly, I made representation. That has not been considered. On the other hand, I was asked to make representation to the other authority. Can you see, my Lord? Page 69, Annexure P11. And last two lines. You are requested to process your representation through the proper channel. Right
Yes.
hand bottom.
Where is the proper channel representation?
Therefore, I made this representation.
Page.
Next page, page 71.
Where is the proof of service of this? Where is the proof of service of this?
The proof of service.
Nothing is here. Please come.
And my Lord, may I?
Not end. Show me the proof of service.
Lord, I'm showing. পাঠিয়েছেন প্রমাণ কোথায় দরখাস্ত রিপ্রেজেন্টেশনটা লাস্ট ব্যাগে নাকি
The petitioner was serving in the military engineer services.
But may I be allowed to?
Posted at Kalaikundo. Stop. He has been transferred to Novogram in September 2025. Stop. Being aggrieved with the order of transfer, he filed a representation before the authority in October, which was returned to him with the observation that he has to process the representation through the proper channel. Stop. Reference has been made to a representation Is there any date of your representation? There is no date. An undated representation. Annexed at pages 70
But
and
the earlier representation has got it.
71 and 72 of the writ petition, mentioning that the said representation was addressed to the proper person.
Person to
through
the other order.
Proper channel. Stop. On a perusal of the subject representation, it appears that the same does not bear any seal or signature in proof of receipt of the same by the authority. Stop. There is neither any postal receipt nor email communication showing receipt of the said representation by the authority. Stop. In the absence of any document in support of submission of the representation before the competent authority through the proper channel, the prayer of the petitioner seeking consideration of his representation cannot be allowed. Stop. Next. In view of the above, the instant writ petition stands disposed of with the observation that it will be open for the petitioner to apply before the authority in the proper manner through the proper channel, highlighting his grievances. Stop. In the event such representation is made, the same shall be considered by the authority in accordance with law. Disposed.
My lord, though it is my lord fault, but may I pray one thing, my lord, that till such consideration, let no course of steps should be taken, my lord. Otherwise,
You have not joined from September?
my lord, actually, I made representation and I was under impression that my representation will be considered accordingly.
So you stay under the impression?
Lordship.
Next.
Next.
47 is also same?
Also same, but here is the proof that I have filed representation afresh and there is a document of proof, my lord.
Please show.
Lordship, just a minute, my lord. Sorry, my lord, for causing inconvenience to you. My lord, that is page 72 and 73. 73.
Where is the proof of service?
Left hand bottom.
Left hand bottom, where?
General copy to G. Kalaikunda, Secretary General.
Forget the copy. Where is the main receipt? Nothing.
Well, I have sent it, my lord. Sorry, my lord, I couldn't carry the track report.
But then there is nothing. And I can see the postal receipt. Where is the track report?
Lordship, that is not here.
Then?
That is not here. So let them consider afresh, my lord. I have sent it.
Same
Postal
order.
receipt is there, my lord. Should they?
Fresh representation.
My lord, may I pray for a time limit so that within that period of time they can consider it?
Sir, the order was passed in October. We are in end of April. There is no proof of service of your representation. And you expect the court to fix a time limit? Call the next matter, please.
Obliged to lordship, my lord.
Lordship, in this matter, Mr. Partho Ghosh is appearing for the petitioner who is engaged in ensuring election. He is a candidate. kindly fix after fourth or fifth.
Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop on such prayer. Released on 4th. Stop. Let notice be served upon the respondents.
Deeply obliged.
We appear for the EC, Lordship.
Yes.
Same player.
Same player. Lordship, 50 to 55, Mr. Parthogos is appearing for the petitioner, Lordship.
50 is 4th.
Monthly list.
Yes. Monthly list.
আপনার জন্য আলাদা মামলা লিস্ট হবে?
Yes.
Great.
56.
My lord, item number 56, I am praying for not today.
Why?
My lord, my senior is engaged in Supreme Court matter, Honorable Supreme Court matter.
So, and this court will not function if the learned advocate is not here. 4th, accommodation sought for, notice be served. Next. Dismissed. (58) dismissed. 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 Dismiss. Dismiss. If for the state, give your appearance, dismiss. Don't call any other matter. Don't call any other matter. Dismiss. If for the state, give your appearance.